Exactly what you said.
In June of 2022, plaintiff Zachary Young, a United States Navy veteran and security consultant, filed suit in the 14th Judicial Circuit Court in Bay County, Florida, against Cable News Network, commonly known as CNN, bringing claims for defamation and libel arising from a November 11, 2021 segment on The Lead with Jake Tapper that Mr. Young alleged falsely portrayed him as an illegal profiteer exploiting desperate Afghans on a quote-unquote black market. Mr. Young was represented by a legal team that included attorney Devin Friedman, and CNN was represented by a legal team led by attorney David Axelrod. The case continued to trial before Judge William Henry, beginning on January 7, 2025, and on January 14th, the plaintiff rested his case. However, on January 15th, Mr. Friedman moved to reopen the case based on a communication between CNN and Helios Global, a government contractor with which Mr. Young had signed a consulting agreement in 2021, indicating that Mr. Young's security clearance had been dropped in 2022. The matter came before Judge Henry as a discovery dispute argued outside the presence of the jury.
The subpoena that Mr. Friedman served on Ralph Otto and the entire civil board fleet, if he did not share with us, I can share that with you too.
Your Honor, if I may respond to that, my cover email to Mr. Otto states, "It is our understanding that you may be arriving in Florida to testify. When you land, we intend to serve you with a trial subpoena, requiring your attendance, and that requires you to bring certain documents with you when you testify. To that end, we are attaching a courtesy copy of our intended subpoena in advance, so that you can have more time to gather the documents, and then when served, it will make compliance easier. We then ask him to tell us when he's arriving to make it more convenient for him and the process server, or ask if he will accept the subpoena. This was not service of the subpoena, this was service of a courtesy copy, so that when he landed, we would hand it to him, and then we would bring it to your attention to say, and to them, and to say, hey, we have now tagged Mr. Ralph Otto in Florida with tagged jurisdiction. He now has a valid trial subpoena to produce documents to us. We were never able to tag Mr. Otto, and so we never ended up serving the subpoena. I was very clear it was a courtesy copy, so I take issue with Mr. Axelrod's half disclosure to the court about what I did. Also, Your Honor, I must take a moment to correct.
Before you do that, is that what the cover letter? I don't have the cover letter in front of me, but there's a certificate of service that says, I hereby certify that the foregoing documents was furnished to all counsel of record by electronic mail on this 6th day of January 2025, the same day that it was sent to Mr. Ralph Otto. And it was never served on us.
Or may I approach? Here's the cover letter. My paralegal prepared a courtesy copy. It says, on my honor and as an officer of the court, it was a courtesy copy. We said it straight out. It is true there's a certification in there, but that's just because I asked my paralegal to prepare a subpoena so we could send it to her, and she simply filled it out. Your Honor, also, if I may just, I feel compelled to simply correct the record because my client has been labeled a liar over and over again. The document, Mr. Young said it was a wet signature, and as you'll see on the document, it is not signed by Helios Global, which means, as Your Honor pointed out, he executed it and then sent it, mailed it back to Helios Global for execution. He did not have it to produce in this document. My client has never lied in this litigation, and in fact, when asked about whether he signed an agreement with Helios Global, admitted it on the stand. Mr. Axelrod was not prepared for that admission, went to impeach him after there was nothing to impeach. And if the court looks at the transcript, you'll hear my objection. He says, I'm going to impeach him, and I said, what are you going to impeach him for? There's nothing to impeach. So he has told the truth over and over and over again. The only thing he hasn't told the truth about is that he didn't know that as of 2022, Helios dropped his security clearance. He had no idea. CNN knew and failed to produce those documents to us when they obtained the documents from Helios Global. And Your Honor, then when the court inquired about how CNN obtained these documents, CNN lied again by saying it was just luck, that it was just sheer luck that we got it. It was not sheer luck, Your Honor. It was the secret subpoena that was sent out. When the court looks through the questioning that you've just seen, you will see that Mr. Axelrod left the jury with the impression that Mr. Young was doing contracting work with Helios Global, something he knew was not true, and which echoes the statements he made to you about Mr. Young committing a fraud on the court, which of course is not true as well. So, you know, and in terms of not listing Helios Global as a witness, of course we didn't, because we didn't have this document. This document was obtained outside the bounds of discovery. It was hidden from us. It was thrown at us as a surprise. We are now prejudiced, and the relief we're looking for, quite frankly, Your Honor, is conservative in my view.
But we're not prejudiced, Your Honor.
And Your Honor, they put an expert on the stand yesterday that said he still has a security clearance, he's grateful, he can do all the work he wants. They knew it's not true. They had their expert get on the stand and say, he's got a security clearance, no problem, he can get work. They knew it was not true. We did not, they did.
That is false. Mr. Young testified he still had his security clearance. We had no idea that that's not true.
Your Honor, if I may, they knew it's not true because Helios Global told them it's not true on January 2nd, 2025. In their letter, they said, we retained Mr. Young's clearance through approximately November 2022 in the event these requirements reemerge. But they did not. Ultimately, we administratively dropped Mr. Young from our security clearance roles, thus ending any relationship/affiliation. So CNN knew that there was no security clearance in place, something we didn't know because we didn't have this communication.
Well, they knew he didn't have it through Helios Global.
Correct.
Well, that's true, Your Honor, but that is, I mean, Mr. Young
Baby girl.
has it through no one else, and what his testimony on the stand was that Ian Conway did him a solid by keeping his security clearance, and I hope he said,
I love you. I love you, banana.
Clearly, Mr. Young's testimony
My
was
girl.
his through Helios Global. That was the only
Oh,
evidence
my
that there
precious
was.
baby
So
girl.
they knew that
You wanna
that
come up here?
relationship ended.
How
They
about that?
knew Mr. Young did not know that that relationship ended, had proof of it, and failed to disclose it to the other side, and then put an expert on the stand to say he still had it. Your Honor, I'm not sitting here asking for sanctions. I'm just saying we have been massively prejudiced, and we should be able to clear the record. The jury should not be misled.
Mr. Friedman argues that Mr. Young has been prejudiced and asks the court for an opportunity to clear the record before the jury. The asserted prejudice concerned the evidence on compensatory damages, the money that a jury awards a plaintiff to make them whole for losses that were caused by the defendant's conduct. In this case, a central question for the jury was whether Mr. Young remained employable after the broadcast, and CNN has maintained that he continued to be employable. In support of this position, CNN pointed to the 2021 consulting agreement that Mr. Young had signed with Helios Global, and by expert testimony that he still held an active security clearance and could obtain work. Mr. Friedman contended that CNN possessed a communication from Helios stating that Mr. Young's clearance had been administratively dropped in 2022, that CNN had never disclosed it, and that Mr. Young himself did not know that his clearance had ended, leaving the jury with a false impression on the issue. Now, because Mr. Young had already rested their case at this point in the proceedings, the request functioned as a motion to reopen the case so that they could introduce the recently disclosed Helios Global communication and call a company representative in to testify. The decision to permit a party to reopen its evidence rests with the trial court's broad discretion. As the 5th District Court of Appeal explained in the 2011 case of Grider Garcia v. State Farm Mutual Automobile Insurance Company, a court weighing such a request must consider the timeliness of the request, the character of the evidence sought to be introduced, the effect of admitting it, and the reasonableness of the excuse for not offering it earlier. Applied here, Mr. Friedman's request was made the day after the plaintiff rested, the evidence sought to be introduced was material to the issue of damages, and due to the timing of the disclosure of the communication, it seemingly could not have been offered earlier.
Your Honor, you can't be prejudiced by introduction of a document that you knew existed. And you already found in the spoliation order that as of December of 2021, Mr. Young knew he was going to be bringing this lawsuit or was contemplating it. You can't get around your discovery obligations by signing a document, then sending it off and saying, I no longer have it, can't produce it. That's what happened here. I mean, he got the
I
contact.
sign a document, send it off. It's within the company's possession, custody, or control. What is my discovery obligation to go to their records, dig through their files, and find a copy of a document I signed several years ago?
That's not what I was suggesting, Your Honor.
It was. It was. You said he can't shirk his discovery responsibilities by signing a document, sending it off, and then say, I don't have it.
He had it, is what I'm saying.
I get court reporter to read back exactly what you said, but I think I verbatim said exactly what you said.
Your Honor, the point I'm trying
I'm
to
tired of these blatant misrepresentations that are being made, and they're being made by both of them. And maybe they're not 100% lies, maybe they're leaving out a little bit of the truth in making representations, so you be careful to say, well, I didn't exactly say that. But you said he's lied to it because he doesn't have any work, but he had no proof that he had work because you're arguing that he signed the security agreement so they could hold his security clearance. But I didn't lie and say he had work. All right, we're taking a break. I'm going to go read this real quick. Let me ask you one last question, Mr. Axelrod. You said, we were going to call Helios Global or whoever it was from there as a potential rebuttal witness. And that's why we served a subpoena. We didn't need to list a rebuttal witness on our exhibit list. But you also had production of documents from non-parties. I remember reading 2 motions to quash that verbatim said Rule 1.351 expressly provides the rule that is the exclusive procedure, in quotes, the open quote, exclusive procedure, close quote, for obtaining documents from non-parties without a deposition. Your subpoena for trial to whomever at Helios had a production request. The motion also says that the motions that I remember reading said that 1.351 requires the notice to the other side. How were you not conducting discovery pursuant to 1.351 in sending a subpoena ducis tecum to Helios Global without giving notice to the other side?
Judge, I'm going to take ownership of that when I called Mr. Freeman this morning after reading the motion. I was asked to prepare a trial subpoena, and the subpoena came across my desk. Paralegal asked me if we needed to send notice of this to the other side. I told her, no, it's a witness subpoena, 38 years.
I don't know.
I've never served copies of witness subpoenas to the other side. I don't recall getting copies of
I love you, baby girl.
There was I was looking at it as a witness subpoena, not a document production request. There was a ducis tecum component to it. I don't recall seeing it, but it was there, and I think I'm responsible for that. So if the rule requires notice of a witness subpoena that has a document production request to it, that's on me, and I take responsibility for that. And I told Mr. Freeman that.
Well, and Mr. Axelrod made the representation that fortuitously we ended up just falling into our lap at the last minute. But it wasn't fortuitous because it was pursuant to that witness agreement.
That is true. Mr. McManus could send it, but we didn't want him to come testify. That is correct.
All right, I'm going to go with this. I'll do that.
Judge Henry questions Mr. Axelrod about why CNN obtained documents from Helios Global, a non-party, without giving notice of the subpoena to the plaintiff. A standard trial subpoena commands a witness to appear and testify, and on its own, it does not trigger the rules governing document discovery. A so-called subpoena ducis tecum, by contrast, commands the recipient to produce documents or things, and when it is directed to a non-party and no deposition is sought, its use is governed by Rule 1.351 of the Florida Rules of Civil Procedure. The rule requires the party seeking production to first serve notice on every other party of its intent to serve the subpoena, with a copy of the proposed subpoena attached before the subpoena issues, so that the other parties have an opportunity to object. The rule also states that it is the quote-unquote exclusive procedure for obtaining documents from a non-party by subpoena without a deposition. Here, CNN served a subpoena requesting document production on Helios Global without giving the plaintiffs any notice at all, let alone the advance notice that Rule 1.351 requires before a subpoena ducis tecum may be issued, which is in violation of Florida's discovery rules.
All right, I went back through and I was reading the trial transcript that preceded the sidebar and then adjourning with the jury and the discussions that we had with the Helios document that was handed, what was it, 589, I think defense 589 was the document that was handed to Mr. Young during the cross-examination. I think I made comments throughout the course of this case about how counsel was conducting themselves, how everything was a surprise, a last-minute thing, how counsel was referring to each other in the course of their arguments, had to impose a $100 fine. I find it rich that we've got discovery being done at the same time a motion to quash is being filed. arguing that the plaintiffs are violating the rules by sending out trial subpoenas when the defense is doing the exact same thing. We have representations being made to the court that we were just fortuitous to get this. It wasn't fortuitous. It was you were doing the same thing that the plaintiffs were doing and sending a trial subpoena for documents without notice to the other side in violation of Rule 1.351 that y'all cited in a couple motions, and just saying that this showed up in our lap. Representing me this morning, we didn't accuse him of anything, having anything beyond a security agreement. But that was clearly the implication that was being made when we were arguing about the document. We wanted to impeach him with it, despite the fact he admitted to signing a security document. And he changed it. We want to use it substantively, and it got admitted into evidence. And it was admitted into evidence under my Binger analysis of something that, there's not prejudice to the other side, was primarily the reason. Had I known it been discovery being conducted after the deadline, there was no way in hell that the document would have been admitted into evidence. Mr. Axelrod, I don't know how many times in this transcript, I didn't bring this paper back with me, how many times you called Mr. Young a liar. But yet in his deposition, he acknowledged having the security being held by Helios Global, which is exactly what that document is, and which was exactly what he testified to. I think an apology from you was clearly in order to Mr. Young for the number of times in front of this court and streamed around the world that you call Mr. Young a liar for failing to disclose a document that you have no proof was within his possession, custody, or control.
Judge Henry admonishes Mr. Axelrod for repeatedly calling Mr. Young a liar because he did not disclose the Helios agreement, despite having no evidence that the document remained in Mr. Young's possession. Under Rule 1.350 of the Florida Rules of Civil Procedure, a party's obligation to produce documents extends only to those within its possession, custody, or control. A party cannot be compelled to produce a document that falls outside that scope, and the absence of such a document from a party's discovery responses is neither a violation of the rules of civil procedure nor evidence of concealment. Here, Mr. Young had signed the agreement and had returned it to Helios Global for execution, which placed the document in the company's possession rather than his own. He had acknowledged signing it and that his security clearance was held through Helios, so its existence was never hidden. Because the agreement was not within Mr. Young's possession, custody, or control, he had no obligation to produce it, and its absence from his discovery responses gave no support to the accusation that he had lied.
Everybody here, I don't know how much money we're clicking off an hour in lawyer bills in this case, and how much credentials the lawyers have in this case. The case has been pending for 2.5 years in my court, and I made a joke. Looking back through this transcript, I made a joke of you only have a week and a half to do more discovery in this case, so we finish up the trial, but seems like everybody wanted to do everything at the last minute without telling the other side that we're going to do this discovery and then accuse the other person of being the bad person. And I said in this transcript, I'm not going to decide the case based on who can sling the most mud at each other and make each other look out to be the worst person. I think it came up in the course of things. This isn't kindergarten. Y'all matriculated from kindergarten a long, long, long time ago. Or at least that's what it says because y'all have bar licenses. I'm troubled by all of this that happened. The easiest thing and the clear thing I'm doing is I'm permitting you to call Mr. Conway and get him here to testify and rebuttal. But I'm overly concerned with the level of professionalism or lack thereof that's here. I'm overly concerned. I mean, the transcript of what I read, we said at sidebar when we were arguing after we excused the jury, conflicts Mr. Axelrod with the argument you made today to me. The argument you were making when we were arguing about the document last week, you were suggesting that, we got the smoking gun. This is the crucial document in our case. I don't know how many times I've heard that from both sides in this case. Or the crucial witness. Like every document, the thousands of documents we have in this case are the crucial documents. But this was being represented as, this just fell out of the sky in our lab, not that we were doing the same thing we were accusing them of being bad people to do. And I take that as a complete insult to me as the court in this case. And you were saying that he completely lied and misrepresented despite the fact he acknowledged that he had a security clearance revoked. Which again, is another misrepresentation to the court which supports your argument that you were being made. So right now your credibility with me, Mr. Axelrod, is about none, if you understand that.
I do. I certainly do. And I apologize when you feel that way. I apologize
if you feel that I've misled you, that surely wasn't my intention.
Judge Henry also reprimands Mr. Axelrod for misleading the court about how CNN had obtained the document from Helios. Under Rule 4-3.3 of the rules regulating the Florida Bar, which are the ethical rules that Florida lawyers are required to follow, an attorney must not knowingly make a false statement of fact to a tribunal or fail to correct a false statement of material fact that was previously made to the tribunal by the lawyer. Likewise, Rule 4-8.4 prohibits attorneys from engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation. Mr. Axelrod's alleged representations that the pivotal document had surfaced by chance, when it had actually been obtained from CNN's own undisclosed subpoena, conflicted with the evidence of record. And as a result of this and other misrepresentations, including Mr. Axelrod's repeated attacks on Mr. Young's truthfulness based on the Helios agreement that we discussed earlier in this episode, Judge Henry informed Mr. Axelrod that he essentially had no remaining credibility with the court.
Yeah, well, you said, oh, I never said that. Well, no, you did. So, today you said I never said that, but that's what the transcript from last week was representing. I'm reserving on any other sanctions pertaining to this matter and other matters against lawyers and parties in this case. But at least to resolve the issue for this morning to go forward, you can get Mr. Conway here, and I'll do this too. If Mr. Conway cannot make it here, we call him via Zoom. All right?
Nothing further.
All right. Is there anything else we need to get before we get the jurors in here?
Carry on.
All right. And let me say this. I mean, y'all made a lawyer like that in Philly or New York or D.C. or wherever the heck it is, or Miami. We don't lawyer like this around here. Y'all may have handled some big cases. We're not going to play the shenanigans anymore in this case. Y'all both understand that? And I'm upping the fine for personal insults to $1,000 per fine from $100.
Judge Henry granted the plaintiff's request to reopen their case, permitting them to introduce the Helios Global communication and to call a representative of the company to testify before the jury. The trial then proceeded to its conclusion, and on January 17, 2025, the jury found CNN liable for defaming Mr. Young and awarded him $5 million in compensatory damages, consisting of $4 million for loss of earning potential and $1 million for pain and suffering, mental anguish, inconvenience, and injury to reputation. The jury also determined that punitive damages were warranted. However, before the proceedings to set the amount of punitive damages concluded, the parties reached a confidential settlement, the terms of which were not disclosed. This hearing demonstrates how an attorney's effectiveness can be impacted by conduct that has nothing to do with the merits of the client's case. As Judge Henry explained, the proceedings repeatedly broke down into accusations between counsel, drawing fines for personal insults and the open frustration of the court. That loss of control over the tone of the litigation served the lawyers poorly, because the judge who had to listen to it was the same judge weighing their credibility. And professionalism and decorum shaped how he received everything that they said. Honesty carried the same weight. Courts rely on the representations that lawyers make, and once a court has reason to doubt counsel's candor on one matter, then that doubt extends to everything else that counsel says. Likewise, because the rules of discovery apply equally to every party, a lawyer who does not know them or who treats them as optional when they prove inconvenient risks both the exclusion of evidence and the credibility of the position being advanced. Even the strongest case can be undermined by the lawyer that's presenting it. And the record here is a reminder that how an attorney conducts themselves before the court is itself part of the representation. Let us know if there is a case or courtroom interaction that you would like us to explore in the comments below. Thank you for watching, and don't forget to like and subscribe so we can help foster a more informed society.
I am the law in this town, and I can promise you. She was all shaken up, crying. Said she was just threatened by a police officer. So I was like, let me look at the cameras, and I look at the cameras, and sure enough, she was threatened, and so was I, and my wife, and my family, and every employee that worked for me at that store.
Imagine that you're a business owner in a small town in Arkansas. This local cop comes in, he confronts your employee, and he starts making all sorts of threats. You've never met him before, you don't know who he is, but apparently he heard some rumor about himself, so he comes in there, and now he's saying that he is the law in this town, and he has all sorts of law enforcement friends, and he's going to cause you some real problems.
I am very, very close friends. ATF, but if I hear my name brought up like that again, I will have this place raided upon but not delivered. And I promise you, that owner, he better watch his P's and Q's and everybody works. Because y'all was in the radar. Man, it bothered me because I know if the shoe was on the other foot, I would be going to jail, you know, and just because he has a badge don't make him be able to break the law.
And it's crazy that this cop was so overly confident that he said, if you have a problem with me, go complain to my chief at the police department.
If there's ever a complaint about me as a person named Jones that works at the Dover Police Department, y'all go down there and y'all complain to the chief as respect for me and his family.
I guess he didn't even think about the fact that there were cameras in the store, and that's exactly what the owner did. He went and complained. But the crazy thing is they said they would need a week to look into it. The store owner gets nervous. He releases the footage on social media and gives it to the TV news stations. All of a sudden, a week wasn't necessary. Boom, the guy gets fired.
On Wednesday afternoon, Jones was dismissed from the Dover Police Department.
But we all know what happens next, don't we? So I sent them an email asking, they're going after his accreditation, right? Right? Credit reporting agency TransUnion suffered a massive data breach in August, exposing sensitive data including names, dates of birth, socials, billing addresses, phone numbers, and email addresses of approximately 4.4 million Americans. The number of data breaches worldwide rises every year. This means that you are at a constantly increasing risk of being caught up in a data breach as your personal information remains exposed online. This is why I highly recommend setting up an account with longtime channel sponsor Incogni. Incogni tracks down and removes your personal data from multiple sites, including online directories and people search sites. The process is fully automated, so it continuously operates in the background, removing your personal data from those sites. I've been using Incogni for several years now, and as of today, they have located my private information in 840 different places. But I also love their custom removal feature available in the unlimited plan and the family unlimited plan, allowing you to take down your personal information almost anywhere that you find it online. So check out Incogni using the link below, or go to incogni.com/civil and use code CIVIL to get an exclusive 60% off just for my audience. Once again, that's incogni.com/civil, 60% off with code CIVIL. Now let's get back to the video. When did this happen? What was the date that this occurred?
It happened on Sunday. I believe it was the 28th of September.
What was the first that you heard that something had happened in your Dover, Arkansas store?
Hey, so at about 4:30 p.m. on Sunday afternoon, I get a phone call from my one of my employees, a woman, and she was all shaken up, crying. Said she was just threatened by a police officer. So I was like, let me look at the cameras, and I look at the cameras, and sure enough, she was threatened, and so was I, and my wife, and my family, and every employee that worked for me at that store. We're on the radar, and we're gonna have us raided by the DTF and ATF. All over hearsay, I guess he heard that an employee had took a picture of him, and I guess it made him irate. You know who I am? Everything. I'm gonna let it be clear that you and everyone else that works here, Kelly, and the owner too. I am the law in this town, and I can promise you, if I hear my name brought up in any conversation, or if I get a rumor about meth pipes and water pipes, if I hear that one more time, I am very, very close friends with ATF. No, I'm just with the mix-up. I'm just telling you. Yeah. You making sure everybody that works here, including the owner and Kelly, whoever else works here. I don't know. I've never stepped foot here until now. I've been here twice. But if I hear my name brought up like that again, I will have this place raided upon, but not believed.
I promise you that. I don't tolerate that shit. I don't buy that pipe, never have, never will. And with my chief knows that I come in here, I'm gonna let him know. If there's ever a complaint about me as a person, Nathan Jones, that works for Dover Police Department, y'all go down there and y'all complain to the chief as respect for me and his family. But when I get told that out in public, and people taking pictures of me like I'm out here buying pipes, I don't tolerate it. I'm not happy about it. I can promise you, it better stop. Because I've never blocked one thing on this place. And I promise you, y'all are the wrong person. I'm just letting you know. You let everybody else know. And I'll promise you, that owner, he better watch his P's and Q's that everybody works here. Because y'all is in the radar now. Don't.
Before seeing that, had you ever met that police officer before, or did you know who he was?
No, sir, I never met him a day in my life.
After you played back this footage, how did that make you feel?
Oh man, it gave me the chills. It gave me the chills because for him to threaten like that when there's nothing going on and no probable cause, and man, it bothered me because I know if the shoe was on the other foot, I would be going to jail, you know, and just because he has a badge don't make him be able to break the law, you know.
Did you ever find out what he was so upset about?
So it was a hearsay. Somebody had told him they seen a message or something. One of our employees said he bought a pipe from our store or some sort of something like that. It was hearsay. He say, she say. Somebody said you sent somebody a message, and it made him that mad.
After you saw this, it upset you. What did you do?
So first thing I did is I contacted my attorney. Second thing I did is I contacted the mayor of Dover, Arkansas, and then I tried to contact the sheriff. Still haven't heard back from him.
What was the mayor's reaction?
They told me let them look into it and they'll handle it, give them a week. But in my defense, if I broke the law, I'm not giving a week. You know, if I broke the law, I'm going to jail right then, right? Especially if I'm right there and there's proof. So my thing was, hey man, I want this guy arrested. You know, he just did terroristic threats. If I did that, I would get a gang enhancement or some other stuff, and I'd be locked up. You know, and it's no different than him doing it.
Okay, and who else did you talk to?
So I went and filled out a statement. I dropped it off with the Arkansas State Police. Then I went to the sheriff's department and I tried to talk to the chief. I still haven't talked to him yet. I'm waiting for his call.
So the sheriff's department blew you off completely?
Yes, sir.
You had a physical meeting with the mayor and the chief of the marshal's office?
Yes, sir.
How long after the incident did that occur?
2 days. They told me that they were going to take care of it, give them some time, give them till Monday.
So have you heard from them since?
No, sir.
I suppose you did see in the news that there was some action by the Dover marshal's office.
Oh yeah, so I did, okay, let me correct myself. I did hear that, so I did get a message from the mayor that they terminated him and that he's no longer on the force. But see, I want more done. I want him arrested because if it was me or any other civilian, they would be arrested, and he has no right to do that and shake up my employees and my business and threaten me and my family.
What was their response to you asking them to have this guy prosecuted?
They're giving me the runaround. They're giving me the runaround. That's what's happening.
Has anything happened since then?
No, sir.
So after the guy was fired, you haven't heard anything else?
No, sir.
Are you still worried that there could be some sort of repercussions against you or retaliation against you for coming forward?
Oh yes, for sure.
Why
For
is
sure,
that?
especially after this week, man, of me trying to turn in papers and trying to get things documented, and them not wanting to document it, and it scares me that I feel like I opened a can of worms, and I feel like I'm gonna have a target on my back, and I feel like all my employees are gonna have a target on my back, and They're already scared to even come to work. They don't even want to come to work because they feel like they have a target on their back already. You know, it's a very stressful. I haven't been getting much sleep lately. My wife hasn't been getting much sleep lately. My employees are stressed out. Like it's a battle you don't want. You know, it's a battle that nobody wants, and it's a battle that nobody wants to defend somebody that's right over the law. You know, because even though they're breaking the law, they still are the law, and think that some of them, not all of them, you know, some of them think they could just do what they want. You know?
When did the video footage first get out there? Was it on the news or was it on social media?
So I believe the day I talked to the mayor and he told me to give him a week, I called my attorney, and then my attorney told me to call Channel 7 News, and so I called Channel 7 News and Channel 11 News. After I called them, I ended up posting the video on Facebook, and then it went viral on Facebook, and then it went viral, and I posted it on TikTok, and then it went viral on TikTok, and then the news came, and it's viral on the news too.
Okay, so you first met with the mayor. He said, "Give me a week." You're sort of scared at that point.
Yes, sir.
And you decide to make the footage public. And then it sounds like only after you did that and people saw the footage and they got outraged at it, then all of a sudden the mayor did need a week and the guy gets fired.
Yes, sir.
That's usually how it works. I think you did well protecting yourself by getting that footage out there as quickly as possible. Do you have any future intentions to do anything else about this? Pursue a lawsuit, anything like that?
Man, I just want what's right's right, man. The guy needs to go to jail. If I did it, like I said, if I did it, I'd be in jail.
Hey, baby girl.
I love my city. I love Dover.
Hey, sweetie.
I wouldn't sue Dover, man. I wouldn't. I just want them to do what's right. That's it.
Is there anything that people can do to help at this point?
Just try to get the video out there, man, because I'm really scared for my family, like something's gonna happen to us just because we put it out there like we did.
I appreciate you talking to me, and I think you did the right thing by getting the footage out there. You know, stay in touch. Let me know, if anything happens, if there is any retaliation, especially any threats made against you, anything like that. So if there are any updates, please let me know.
I will do, man, and thank you for interviewing me.
So only after the owner of 479 Smoke Shop makes this video footage available to the public for them to see, only then, it sounds like, does this police officer, Nathan Jones, get fired. And he gets fired immediately, and the Dover Marshal's Office issues a press release, October 1st, 2025. Here it is. The Dover Marshal's Office is committed to upholding the highest standards of professionalism, integrity, and service to our community. Recently, we were made aware of an incident in which a part-time patrol officer, while off-duty, entered a local Dover business and made statements to an employee that did not reflect the mission, values, or professional standards of this department. To be clear, we at DMO believe the remarks made were contrary to the Dover Marshal's Office's commitment to fair and impartial enforcement of the law and to the principles of professionalism we expect from every member of our team. After reviewing the recorded incident, the matter was addressed, and the officer has been relieved of duty. We want to reassure the citizens of Dover that this department does not and will not engage in the targeting of individuals, nor do we conspire with other law enforcement agencies to do so. Investigations conducted by Dover Marshals always begin with a reported or discovered crime, never with an individual. The Dover Marshal's Office remains steadfast in its mission to protect public safety, serve our community with integrity, and maintain the trust placed in us by the citizens of Dover. And since there was a media contact listed with an email address, I emailed them to ask the obvious question. We all know what happens. The guy gets fired, and then he goes the next county over or the next town over, and he quietly pops back up there. Well, that was a couple days ago that I sent that email, and did I receive a response? No. I received no response from them, even though they solicited media requests, which I take that to mean that they did not take any additional action in regards to this guy. We just recently saw this, I think it was in Texas.
Why did you take off from that stop? I stopped. Why did you take off from this stop? You better give me
The guy pops up the next county over. Okay, so of course I was mistaken. The video from a little over a month ago was actually from Arkansas, not Texas. And that's the situation where I had called the sheriff's department and actually spoke to the sheriff. And I thanked him for taking quick, decisive action on that guy who had abused that elderly man who had been suffering from dementia. But what I did not know at the time, in reality, what that sheriff had done is, yeah, he fired that guy, but then he was on board with the guy getting hired like the next county over. And I believe he acknowledged to them that he was a good cop, but for political reasons, basically he had to let him go. And that's the common thing that happens all the time. And so I was researching when I was making that video that in Arkansas they have this Commission on Law Enforcement Standards and Training, CLEST, and they established the minimum standards for employment and continued employment, including minimum standards of education, physical, emotional, intellectual, and moral fitness for law enforcement officers in the state of Arkansas. And the guy who was the director of that, Chris Chapman. So I had attempted to email Chris Chapman about the case from a month ago, and of course got no response from him either. This seems to be a common reoccurring theme in Arkansas, where bad cops get fired and these guys do nothing, allow them to pop up somewhere else. Clearly here we have a law enforcement officer who does not need to ever work as a law enforcement officer again. He was caught on video violating the trust that was placed in him, the authority, the discretion that was placed in him. He is not trustworthy. He is not trustworthy to ever be placed with that responsibility ever again. And I really don't see how anyone can argue with that. That's why he was fired. Though I don't think he would have been fired but for the fact that the store owner captured video footage. You know, for those of you in Arkansas, people ask me, well, what can I do? This is what needs to be done. These useless government agencies full of these useless leech bureaucrats who aren't doing their job. They're protecting bad cops instead of getting rid of them. They're not doing their job, and this is a government of the people, by the people, for the people. If they're not going to do their job, let's get rid of them. You can also help by sharing this footage, liking, commenting, sharing. That gets the algorithm going, and they will put this video in more and more people's feeds who would not otherwise see it. And the more people who see it, the more likely it is that there will be some sort of accountability here. If I hear anything else, I'll let you know. You can follow along by subscribing here and at the blog at thecivilrightslawyer.com. You can follow me on X at JohnBryanESQ. Remember, our rights don't end where your fear begins. Freedom is scary. Deal with it.
Michael, come to the door. I don't need a warrant to talk to you. The consensual contact is declined. This is not a consensual contact. This is an investigative detention. Come to the door.
A bandit of cops showed up at your front door and they banged on the door, demanded that you come outside and answer their questions. Why? Because the contractor working on the house next door told them that you yelled at him. Andrew hurt his feelings. Knowing your rights, that the police can't just stand on your front porch, detain you, force you to answer their questions, shout things at you without your permission, you tell them to leave. You even call the cops on the cops.
I received your message, Michael. I'm not going anywhere and I'm not trespassing. So come to the door. You are trespassing. Okay,
I mean, they don't have a warrant and they don't have your permission, right? But even though the courts have said that this violates your constitutional rights, what if the cops just don't care?
You turn the doorbell off? Yeah.
we're not going anywhere, Michael. Come to the door.
This footage was submitted by Michael. This is his house that you will see in this video. This happened in Coolidge, Arizona. It involves the Coolidge Police Department, and it happened back on October 17th of 2025. These police officers were dispatched, quote, in reference to a disturbance. Now here's what Michael said happened. There's a contractor who was doing construction work on the home next door. He noticed that the construction work was starting to encroach on what he believed was his property, and so he had a conversation over his wall with the contractor on the other side, and that escalated into an argument. There was no physical assault, there was no threatened physical assault, it was just an argument. Apparently that hurt the contractor's feelings, and so he called the police. I do have the 911 and dispatch records. The officers who arrived, they were just told it was a disturbance with a neighbor who was, quote, yelling. There was no indication that anybody was ever in any physical danger, that any assault had occurred, or that it was ongoing at all. It was just allegations that a neighbor had yelled, like past tense. So the cops arrived and they talked to the neighbor first.
Actually, look at my hands. Dude, I need to eat it, bro. Okay, sir. No, I work for the guy that bought it. Yeah, the owner, he is a teacher. But I told him to let him know also. Okay, no worries. Or he just takes it out. Not my property. Yep, right there on this side of the wall. Yes, sir.
You were saying, when you were saying, it's like, what, we got a problem. You were doing a motion like this, like, they see you flaring up. Yeah. Hell yeah, bro. Him, man, if that wall wasn't there, they wouldn't charge me, bro. Him and the younger dude, whoever the hell he was.
So at first, the contractor alleges that Michael actually trespassed onto the lot that he's working on. And then answering the cop's question, he said, yeah, the neighbor was being really aggressive. If that wall wasn't between us, then something might have happened. Basically admitting that Michael was at all times on his side of this wall. Not that these cops seem to care, as they already refer to Michael as the primary aggressor and are asking all sorts of leading questions to this guy, almost as if designed to incriminate Michael and not caring about the other side of the story.
They were saying that what they can't look over here, or they can't say anything across the wall. I mean, you guys can do whatever you want. I'm not saying you guys can't do anything.
And
My boss calling me.
the primary aggressor was older.
Yes, sir. Yes, sir.
And actually, it seems that these cops know Michael. They apparently had prior interactions with him, and I guess they don't like him. It seems like they've already predetermined that Michael did something wrong, and they march over to his front door and they start pounding on the door.
It's cameras everywhere. He knows he's wrong. He's not answering, bro.
My dad was playing.
Okay.
I think that. No, I didn't hear you.
Yeah.
Coach, police department, come to the door.
So far, the officers have walked up to the front door of this house. They've banged on the door. They've rang the doorbell. but the occupants of the house have not answered the door. Meanwhile, the contractor yells over to them, complaining that the occupants of the house have now called his boss, and they told his boss a completely different story than he was telling the police.
Hey, you just they're gonna blowing my boss up right now and telling my boss a whole different story. I'll tell you guys right now.
Okay.
And that's when the cops mentioned that they know who this guy is, that they have a 21 on him, whatever that is, and that at least one of them had received rude messages from this homeowner. And so what do? They continue to ring this guy's doorbell repeatedly, multiple times, and continue to bang on the door, despite the fact that the guy clearly doesn't want to answer the door.
We definitely have a 21 for him. I've gotten the rude emails and all that craziness.
Okay, so,
Yeah.
Coolidge Police!
They've rang the doorbell now so many times that Michael apparently just turns the doorbell off. Then they realize that he turned the doorbell off, so what do? They continue to do it more. And the one cop just obnoxiously continues to pound and pound and bang on the front door of this house.
You hear that? You turn the doorbell off? Yeah.
We're not going anywhere, Michael. Come to the door.
You can turn it off for 15 minutes or much. Yeah. You want to forward the charges then? Yeah, oh, he so already deleted it. Yeah.
Clearly the officers aren't taking the hint, they're not leaving, so Michael then actually calls 911 on the cops and advises them that these officers are at his door, that he does not wish to speak with them, that they are trespassing, and he wants them to leave. So dispatch relays this to the officers, and their response to that is that they're not going anywhere. They are refusing to leave, and the one officer tells dispatch to tell Michael that they are not going anywhere.
I received your message, Michael. I'm not going anywhere and I'm not trespassing, so come to the door.
You actually are trespassing. You guys are both dismissed. Thank you.
Okay, absolutely. Come outside and talk to us.
No, I'm not going to
We're investigating the situation. Come outside and talk to us.
Since the officers have been there, pretty much what they've been doing is one of them is just obnoxiously pounding on the door trying to get Michael to come out of the house, and the other one is sort of just collecting evidence. He's listening inside the house to hear what he can hear, and he's trying to look through the windows. He's essentially gathering evidence. So finally, Michael opens his interior door and tells them to leave, that they're trespassing, to go away. And the one cop who's collecting evidence basically mentions that, oh man, he smells marijuana when the door opens.
Oh man, it reeked of pot as soon as you open the door.
So these two cops are at the front door. They don't have a warrant. They're refusing to leave. They finally made contact with Michael. Michael tells them to leave. They still refuse to leave. But Michael isn't giving in. He's still not coming out.
He's on the phone with someone telling them we're trespassing.
I didn't know.
Yeah. Oh, someone just told him we're not trespassing. He goes, that's not true.
Michael, come to the door.
No, you don't have a warrant. You need to leave.
I don't need a warrant to talk to you.
The consensual contact is declined.
This is not a consensual contact. This is an investigative detention. Come to the door.
Is this a consensual contact? The officer here actually denies it, but for his sake, he better hope that he's wrong, because only a consensual contact here would be legal. As the Supreme Court held in the 1980 case of Payton versus New York, absent valid consent or exigent circumstances, i.e. an emergency actively occurring, law enforcement may not cross the threshold of a residence without a warrant. Not to search, not to arrest. So even if a police officer has probable cause to make an arrest of somebody for some crime, Payton versus New York says, sorry, you have to come back with a warrant. It doesn't matter what the contractor next door told you. The contractor could have recorded a crime on video, showed it to the cop, and this cop still could not legally arrest Michael without a warrant, much less detain him because he's in his home, at least not without a warrant. Does this apply equally to the front porch of a home? Yes. As the Supreme Court held in the 2018 case of Collins versus Virginia, police cannot enter the curtilage of a home, which is the area close to the home that's treated as a part of the home, such as an enclosed yard, garage, driveway, or, as here, porch, to search a vehicle parked within the curtilage of that home without a warrant, even where they have probable cause. Pretty much all the federal courts, including the Ninth Circuit, which applies here, have held that this is common sense and easily understood that an area an arm's length from one's home is curtilage. Here, this encounter is taking place directly at the front door on the front porch of Michael's home. So this is both on the front porch and also an arm's length from Michael's home. So there can be no doubt that this is taking place within the curtilage of this home. Police officers in Coolidge, Arizona, just like every other town in America, have no special right to trespass on your property and just to remain there outside your front door until you come out of your house. Though they seem to be always ignorant of this across the country, as I recently featured in the 911 butt dial case from Owensboro, Kentucky.
We can smell marijuana. That still gives us the right to come in and search for that, okay? No, it does. I don't have to have a warrant when I can smell it.
Although officers did not enter the home, the Owensboro Police Department acknowledged the officers were incorrect in stating they could enter the residence without a warrant to conduct a search.
Where after I did a video on this, the city came out publicly and apologized for violating the homeowner's constitutional rights in the same way that's occurring here. So what can they do? All they can basically do is what's called a knock and talk. The so-called knock and talk exception to the warrant requirement isn't really an exception at all, but it does allow police to enter into the curtilage of a home to ask questions of its occupant, precisely because that's no more than any private citizen might do. So while police, like the nation's Eagle Scouts and trick-or-treaters, can approach a home to speak with its occupant, nothing in the implied license to have that consensual interaction suggests that a visitor can restrict the movements of a homeowner next to his own home, any more than a Girl Scout could force the resident to buy her cookies or to hand out candy at Halloween. The fact is, there is no right to detain, arrest, or otherwise seize the homeowner implied by the license to perform a knock and talk. To the contrary, that implied license may be revoked at any time by the homeowner. Here, there can be no disputing the fact that Michael revoked any implied consent for these cops to engage in a knock and talk.
I received your message, Michael. I'm not going anywhere and I'm not trespassing, so come to the door.
You actually are trespassing. You guys are both dismissed. Thank you.
Okay, absolutely.
He asked them to leave, and he even called the cops on them. Also remember his no soliciting sign. There might even be a case to make that Michael didn't even have to revoke their implied license because it never existed due to the no soliciting sign. Though the case for that would be stronger if the front curtilage of his home were fenced and gated, with the no soliciting sign being up at the closed front gate. Not that these cops would have cared anyways, though.
Can you turn the doorbell off?
See?
Yeah.
We're not going anywhere, Michael. Come to the door.
So let's continue.
You can't write warrants for
I don't think anyone will sign it. A warrant for this one?
Come out and talk to us. We need to figure out what's going on.
What did she say? He told her that he spoke to Fitzgibbons and the chief and that we need to talk to his lawyer.
That's probably the going around trespass.
Yeah.
I'm calling it.
Okay.
Stop walking on the rocks. It's a violation of general orders. Only walk on the common ground. Please leave my property. This is illegal. You're standing on my rocks, dude. That's a violation of general orders. Get off my rocks. Get off my... Tell that man to get off my rocks, and you leave. You're both trespass.
And we have multiple counts now.
Get off my rocks. You get off my rocks. Get off my rocks now, dude. You get off my rocks. You're gone. Trespass. Bye. Bye.
Yeah. Well, I'm going to inform him to the door that the coordinate. Fantastic. All right, good. All right, Michael, just for information, I'm going to be forwarding disorderly conduct charges against you. You heard me. I will be forwarding disorderly conduct charges against you to the city. Okay, so be expecting a court date in your mailbox. Or you can come out and talk to me and we can figure out what was going on. Shut the door. Okay. Let's go.
All right, so let's recap. The neighbor's contractor calls the cops, accuses Michael of yelling at him. The cops arrive. They already don't like Michael because he sent them some mean emails before, and so they walk onto his property in order to question him. They walk onto his property just like Girl Scouts or trick-or-treaters would enter, up the front walk, knocking on the front door. They have no warrant, there is no actively occurring emergency requiring them to rush in without one, nor do they have Michael's consent to enter, obviously.
You actually are trespassing. You guys are both dismissed. Thank you.
Okay, absolutely.
The only so-called right the officers have is the same implied license to engage in a consensual encounter, just like Girl Scouts. But then the cops don't act like Girl Scouts. They obnoxiously pound on the door for extended periods of time. They ring the doorbell over and over and over again and demand that Michael come outside, claiming that he's being detained and threatening criminal charges against him, which, by the way, never arrived. They never did charge him with anything. Michael expressly demands that they leave, and he trespasses them from the property, even calling the cops on them. But the cops refuse to leave, and their superiors don't require them to leave, at least not for quite a while. They do this despite the fact that the Ninth Circuit has said that these officers are violating the Constitution by refusing to respect the Fourth Amendment protections of the home. I mean, clearly, they do not care at all about constitutional rights. Why? Because unless someone is watching who knows better, they generally just do what they want to do and they get away with it. But now I've seen it and I've shown it to you. For reasons that I have already explained in detail, they have no defense to this. They violated this man's rights, and the question is, what will they do now? Will they do like they did in Owensboro, Kentucky, and publicly apologize and order their officers to undergo additional training in constitutional rights? Or will they gaslight their public and claim that they did nothing wrong? I guess we'll see, but we will only see if you help put this footage in front of as many eyes as possible. You can help push this footage in the algorithm by commenting and discussing the video, as well as by liking it and sharing it. And if I hear of any response from them, I will update, and you can follow along by subscribing both here and at the blog at thecivilrightslawyer.com. You can follow me on X at JohnBryanESQ. Remember, our rights don't end where your fear begins. Freedom is scary. Deal with it.
Y'all own this? Y'all own this property?
That's the thing. We do, ain't we?
That doesn't mean you own it.
We own it.
Let me see your IDs.
You need to get off our property.
Let me see your IDs
Get
now.
off our property.
Let me see your IDs now.
A married couple was sitting in their car in the rain on their own property, minding their own business. Out of seemingly nowhere, a sheriff's deputy appears. He drives onto their property, he gets out of his car, he approaches them. He thinks their presence is suspicious, and he begins to ask them questions. But they didn't want him on the property, they told him to leave. But he did not leave. He ends up putting the husband in handcuffs and in the back of his patrol car. After a little while, the deputy acknowledges that these are the homeowners.
Yep, you are the property owner. Again, I didn't know that full enough.
He lets the husband out of handcuffs, but understandably, they are not happy at all.
He arrested my husband on the property.
She later uploaded that video to social media, where it went viral and even made the local TV news. In the news report, which the sheriff's office calls one-sided, the couple makes the allegation that they were victims of racial profiling.
And I see two black people sitting in there. They have no business there.
I did reach out to the sheriff's office to get their side of the story. They provided me with the police reports and the original raw footage. So who was right and who was wrong here? Was there racial profiling? Were this couple's constitutional rights violated? Well, I have an answer to that, at least in my opinion. So let's go through it and you can form your own. Some of you have sent me messages about my beard, that it's too long, it's too shabby, it's unprofessional, I need to do something about it. And to make matters worse, last weekend I actually caught my beard on fire because I got the grill too hot. Thankfully, I now have this sweet little machine. The Beard Hedger from Manscaped is the perfect companion for sculpting and styling your facial hair. It features a titanium-coated stainless steel T-blade with 20 different length options. You just choose your length with the zoom wheel. In minutes, you can achieve any look from neat stubble to a full-on beard masterpiece. But that's not all. The Beard Hedger is waterproof, so you can use it anywhere you want without worrying about water damage. It has up to 60 minutes of runtime on a single charge, so rarely will you have to worry about unplugging all of your wife's gadgets to find an outlet. Plus, the 3-level LED charge indicator lets you know when it's time to charge, so it doesn't die on you at the worst possible time. The Beard Hedger comes with everything you need to up your beard game, including all the cables, a comb, a travel bag, perfect to take on the go, or you can get what I got, the Beard Hedger Pro Kit, which also comes with everything you need, but also more, such as the shampoos, the conditioners, the oils, the beard balm, the beard scissors, the beard brush, the beard comb, the storage case. I highly recommend these products and can get you now 15% off your entire order when you use code CIVIL at manscaped.com or using the link below. That's 15% off with promo code CIVIL at manscaped.com/civil. Now let's get back to the video.
A video of a Marion County Sheriff's deputy detaining a man on his property is getting hundreds of reactions on social media.
He arrested my husband on the property.
Not under arrest.
I don't care. You put him in handcuffs on the property. On our property. Racial profiling us. He pulled up on our property and said that we are trespassing on our own property. Can you believe this? Now he's taking the handcuffs off my husband on our property still. It's so wrong, and this police department will be sued. I'm going to see my lawyer tomorrow.
Someone just pull in and ask, what are you doing here? Then we tell you we live here.
In my mind, you're thinking, oh, I see an old Honda 2000 Accord parked in front of a nice new construction building, and I see two black people sitting in there. They have no business there.
Welcome back to the Civil Rights Lawyer channel, where if you're a subscriber and you watch these videos, you'll be able to answer the questions such as, what is the one and only thing that you should say to a police officer if they approach you like this on your property? This comes to us from Marion County, Florida, which is the Ocala, Florida area. It's sort of rural, horse country. This couple apparently lives already on the property, and they're building this new construction barn dominium. And this construction site is all brand new. I looked it up on Google, and it doesn't even show the barn dominium yet, much less the driveway coming in. They also put in new fencing and a gate, which is important for reasons we'll get to. So like many other videos that I do, no crime is reported at all. There's no 911 call. Nobody has requested the presence of police.
ID card. Something with your name on it. That's my mom. Stop, dude. You can make an emergency, please. I got one resistant.
This is just a police officer out on patrol, being proactive, and he sees something that he thinks is suspicious. So what did the officer think was suspicious here? Just two black people sitting in a car? Well, these are his own words to his supervisor about why the interaction began.
I was driving by, it's a new construction, they're starting a barn dominium out here. So I keep an eye on the place because I know how often those places get hit. So as I'm driving by, I see a vehicle park in front. This is completely unfinished. They've got the sidings done, but the inside isn't even touched. I see a vehicle parked in front of the house. Taillights are on, it looks occupied. So I walk up, go make contact. I'm like, hey, what are y'all doing here? Just trying to talk to him. The guy gets instantly aggressive and defensive, starts screaming at me to get off his effing property, says he owns this. I'm like, okay, if you own it, can you see some ID? I'll verify that and we'll be good.
And here is the beginning of the body cam footage, where we can see that the car at the time that the deputy first arrived, since it's raining, the car window is up. It looks close to impossible from that distance with the car window up to tell who is sitting inside that car. So he pulls onto the property through an open gate, he gets out of his car, and he walks up to this Honda Accord. And as he's walking up, they're rolling down the driver's side window, and that's when the interaction begins.
You own this? Y'all own this property? That doesn't mean you own it.
You own it.
Let me see your IDs.
You need to get off our property.
Let me see your IDs
Get
now.
off our property.
Let me see your IDs now.
So you get off our property.
Put the car in drive. Put the car in park.
No,
Let me
you
see your
need to
ID.
get off our property.
Someone know you ain't being non-cooperative.
That's crazy what he got going on. You come pull in our property, tell us get our ID. Get off our property, man. You know
Give me your ID.
No trespass.
My last name is Artman, A-R-T-M-A-N. My ID number is 6057.
Get off our property. No, you need to do. Get off our property now.
Ma'am, do you have your ID as well?
No, I have to go back down to my where I write down here.
That's fine. I can just write down your information. That's fine.
Why is you here?
The new construction house. I see a vehicle sitting out front, running with the lights on.
House. This is my home.
Hey, calm down. If it's your home now, leave it alone.
For putting up in our house.
Baby, no. I'm going to call 911 myself.
Call him, baby, now. You dead ass wrong.
Cut off it.
Racial profile.
I didn't know who was driving.
That's what you did.
Cut off.
I don't like that shit. Stay the off our property. Get off our property, man. That's all you got to do. We told you we own it. We own it. Call him, baby.
Ma'am.
Call him.
Ma'am, what's your first name?
No, I'm calling 911.
And here's more of the deputy explaining to the supervisor about why he thought this couple was suspicious.
he wants to get argumentative and screaming at me, and then the wife starts screaming at me, and he provides me this VL, and it says 17335. The house number is 17337. So the numbers are close, they don't match. So I still don't know that they actually live here or have the right to be on the property.
By the way, I looked up both of those house numbers on Google Maps, and both of them came back to exactly the spot where this incident occurred. And as a police officer going off a hunch, where no crime is reported, you're sort of out on a limb. You have to always sort of ask yourself, I think, why am I here? What am I doing? What am I trying to achieve? It's like at some point the investigation becomes an investigation to justify the investigation, and they forget the entire reason they were there in the first place. All right, this suspicious vehicle in front of this new construction site. Well, he talked to them, they said they lived there, they told him to leave, they provided ID that was awfully darn close to where he thought he was, and they called 911 on him. That might have been the point at which he could have thought to himself, you know what, maybe I'm wrong. These people have just called 911. I have their ID information. Maybe I just leave because they told me to leave. But that's not what happened.
Listen, until I can verify this is your property, I'm conducting a criminal investigation. Therefore, you need to provide me with your name. Something with call 911. What is it provide information?
I don't know, but he's on our property telling us we don't live here. Can you have somebody come out here right away?
We don't own our property.
The address is 17335.
That's crazy.
North Highway
Just pull up in somebody's property in the rain.
You think I want to be out here standing in the rain?
You dead ass wrong, man. You dead ass.
I don't know why you gotta be hostile. I'm trying to do my job.
You being hostile.
I'm not being hostile.
Cause you just pull up on our property and acting like we don't own that.
Wait, you cannot do that.
You dead ass wrong.
65 the tag.
The deputy radios the car's plate number to dispatch, and literally as the dispatcher is reporting back the information on the plate, the husband starts to get out of the car. Now, mind you, they are on their own property. They are not under arrest. They have not been told yet that they are being detained. As far as any citizen in that situation knows at that point, it's a consensual encounter. There's no way of knowing because they haven't asked and the officer did not say. The officer then makes a split-second decision to undoubtedly turn this into a detainment.
Hey, stay in the car. Stay in the car. Get back in the car.
Man.
Get back in the car now.
This is my property.
Sit back down in the car.
I ain't being detained.
Yes, you are. Until I can verify you.
No, you don't verify. You don't read it in my name already.
All right.
And also put the husband in handcuffs.
Hands on your back. You're being detained right now. Hands on your back. Put the phone in the car. Put the phone in the car. Drop the wallet. Hands on your back. Hands on your back. Right now, you're being detained, okay?
I'm gonna sue you. No, I'm gonna sue you. I'm gonna sue you.
Again, they're acting like he's guilty until proven innocent. So he's detained until they can verify that he's telling the truth? No. No. Innocent until proven guilty.
Walk over to the car now. Man, have him step it up, please.
Dead ass wrong, man. You dead ass wrong. This is my home.
You have anything in your pocket so stick me, poke, or prod me?
No,
Any
I
kind of
don't.
weapons on
No,
you?
I don't.
Nothing illegal? No illegal substance? Break your feet for me.
He's put him in handcuffs behind his back, and he's about to put him in the back of the police car. And what we just witnessed on the body cam was him asking questions where he's fishing for incriminating information. Do you have anything illegal on you? But he's also fishing for what should be justification to frisk him. Do you have any weapons on you? Now, the husband said no, but the deputy frisked him anyways. We saw him do it. But according to the U.S. Supreme Court, to frisk somebody during a detention, during a Terry stop, to perform a Terry frisk, a police officer has to have information that the individual is armed or dangerous. Here he said he was not armed, and there's no indication that he's dangerous, at least not that I've seen. Unless the officer can explain why he believed that this man was armed or dangerous, that was an illegal frisk, which is an illegal search and seizure.
Oh, watch the door.
throw my food
I see
down
something.
and everything. You dead
I
ass
didn't
wrong,
throw
man.
your
Yes, you
food
did. You see me eating, man. You that ain't right. This is
Watch
my
your arm.
home.
Watch your arm.
So now, very quickly, we've gone from a conversation to the husband being placed in handcuffs and put in the back of the police car. That means that there's no doubt at this point that a detention is occurring as opposed to a consensual encounter. Therefore, the Fourth Amendment is implicated, which then requires the question, was the detention justified? Or also, depending on how it occurs, the detention could turn into an arrest. If it ends up lasting an unreasonable amount of time under the circumstances, or it goes down in some unreasonable way. Here is the deputy's explanation to his supervisor about why this occurred.
He starts getting out of the car. I said, sit back in the vehicle. He wouldn't listen. I didn't trust him, so I detained him and put him in the back of my car. Before I even did that, she called 911.
So he has the guy's ID as he waits for backup to arrive. He walks over to the front gate of this property, and he notices that there's actually two different numbers, one of which does match the guy's ID.
67. The mailbox says 17335, but the fence says 17327. Could possibly be the alternate. Starting at the internet.
And after this point, is it reasonable to still be suspicious that the guy could be trespassing on some third party's property, but just happens to have an ID with his picture and at least one of the two numerical addresses for the actual property?
He provided me this DL, and it says 17335. The mailbox says 17335, but the fence says 17327.
Pretty much statistically impossible. But like I said, now sort of investigating to substantiate the investigation.
10-4, that's gonna be possible. Okay, where's the house that's 335?
Where the house is. You wait till the other officers get here. Don't worry about that.
Listen, I don't know why y'all have to be so aggressive and hostile. You know what? Okay, listen. Can I explain a little bit? Can I explain a little bit? No? Okay. So next time, I'll let someone just come in and break in and steal stuff. If you want to play that, ma'am, how was I to know that was your property? How did I know it was your property? How did I know?
Because they told you.
How did I know it was your property?
You don't have to know.
Not arrested, he's being detained.
Oh my god. When did this whole detain thing start?
I didn't know. Oh my goodness, I'm not arguing.
Now he's getting frustrated, which is very unprofessional.
Where's the house actually at? Because the number on the fence is different than the mailbox. Listen, where is that house at? The 17335, where's that house at?
This is new construction house right here.
Okay, this house, what is this house number right here?
Right there on the front page.
The 17327? Okay. That's simple. The 17335. Where is that house at?
What you mean where it's at?
This is 17327.
This is property. This is all one property.
You know, if we just talked about it, it would have been a completely different conversation.
You never did that, sir. You just put in here, assume something, and act what you do. I own this. That is wrong, man. You got these clubs on me tight, and we stay here. This is our property, sir. We told you that.
It was at this point that the deputy gets back out of the car, and then he calls the supervisor on the cell phone. I already played you some of that conversation. Here's where it picks up.
He appears to live in the house behind the property. 10-4. But there is, but I can't see the house number on the building. There's a mailbox that says 17335, and then the fence post says 17327. I didn't see the mailbox when I pulled in. I only saw the number on the fence post. And on top of that, it's a new construction. There's a car sitting out front with its lights on. I mean, how many times do we get them things broken into in broad daylight? But she's screaming, hooting, and hollering, and won't give me her information. I'm like, you know what? If I can verify that she's his spouse and they live at the house behind, then okay, we're good. That's all I needed. She, on the registration of the vehicle? Oh, yeah. I didn't get a chance to. I was just trying to talk to him. Then he started getting out of the vehicle, and I was like, I don't trust that you're not about to either run or fight me, so you're gonna sit in my car. I'm not trying to cause crap for you, sir. I'm sorry, but just that's all it is right now. But he's already pissed off, and they're all talking about suing, and they're gonna file a complaint anyway. So I'm sure you'll see it. All right, I'm still gonna need one of them here, so I can at least, if we can talk to you at the house to verify that they live here and they have the right to be on the property. Awesome. I just can't go back there right now. And they're all claiming that I came out here and was being aggressive and stupid with them, and I wasn't. I was trying to verify who they were. Yeah, and I don't doubt that. I didn't know there was another house behind this. I couldn't see it from the road. It just looked like it was a big driveway with a big piece of property. Yep, we'll do. All right, bye. We're not going to take them off right now, but if I can verify that y'all live at the house behind, which I see your ID says that, I don't see the house number in the back there. Once another of you gets here and verifies that that's your address, then we can get this done and over with. All right, I wasn't coming out your profile on you. I didn't know that until you gave me your ID, all right? And even then, I can't see that house back there.
No, just loosen the head coat. Please put him in the corner.
Yeah, hold on 1 second, I'll loosen them. Alright, here's what we're doing, Mr. Jackson. Kind of turn your back, face that way. Which one's tight right now? Both of them? Okay, alright.
I ain't going nowhere, man.
No, wait.
I'm not going nowhere, sir. This is my home.
Again, Mr. Jackson, I don't know that until I verify everything, alright?
I'm just saying.
Alright, here's what we're gonna do. Go and step out, I'll put them around in the front, and then then we'll sit back inside, okay? Okay, just go and face the car for me, okay? You good? You good? Tight. Alright, face the car for me, okay?
He ain't arresting me, baby.
He's not under arrest.
I don't care. You put him in handcuffs on the property.
Right now he's just being detained. Okay, so when I release your left arm, just turn around and face me and I'll put him in the front, okay?
On our own property. Can you believe this? Now he's taking the handcuffs off my husband on our
Listen,
property still.
do me a favor, I don't care if you record, take a couple steps back, okay? Take a couple steps back.
Step back, baby.
Step back.
Step back.
Please.
Because there's wrong with it.
Okay?
Step back.
Alright, face the car for me.
I'm going to see my lawyer tomorrow. Just want to show you what happened.
Stupid kid, you stupid. Hold on, you alright?
You need to go live, baby.
Turn and face me. Just go like that. Go like that. Nope. Turn your wrist that way. There you go. I don't want it to turn sideways on you, okay? Alright. I'll adjust this one, okay? I did not mean to make you drop your biscuit. Alright?
Somebody tell you they stay here, we stay here.
Yeah, but here's the thing. How do I know it's all here? No, it's not.
You should never put on nobody's property, man. I ain't gonna argue with you, but you did wrong, and you know you wrong. You in big trouble for this, bro.
It's a matter of opinion, alright?
What? Jesus.
Alright, so she's just sitting over hooting and hollering and recording. I don't really care about that. I need to try to
Hooting and hollering.
the badge they have on his license. I need to
Oh my God.
the badge back behind there. Because you saw the fence has one number. Yeah. The mailbox has a different one. Okay. Didn't see the mailbox when I pulled in here. I was focused on the car because where they're parked at right now, the car was sitting there, lights on. I could see someone was moving around in it. And it's the new construction, so I figured, hey, 13, I need to check it out. So I flipped around.
Did you look at the lot box to see what the address is on the lot box?
No, they told me the address for this property is on one of the fence.
Just give us a minute.
And this is the whole time.
Okay, we're on it.
I need to try to get on property repairs if I can't get it.
Ma'am, that's fine. You do what you want. We're doing an investigation. Ma'am, just give us a minute, please. Just give us a minute.
I already tried to explain. Yeah, she was. That's you see. I couldn't even tell what kind of it just don't ignore it. I can go check the lot box. See, would they have the person's name who owns the property on that?
Yeah, everything should be on the job box.
I didn't. Again, I was focused on the car because of all this crap. It's a nice freaking barn, though. Angela, yeah. Yeah. But again, didn't know that off the bat. Actually, hold on, let me take a picture of that, 'cause I'm gonna probably end up writing something on this anyways.
So what is, you don't have anything, right?
Nope, we're good now. I just didn't have the chance to get that because I was focused on them. Hey, because I was focused on the car, I didn't see the lot box there. And even then, I was focused on them. So Joe just pointed that out, went over and checked it, and both their names are on the lot box, which is in front of the construction that they were parked in front of. So I got nothing. I'm going to cut him loose. Yeah, I'm going to write up a do you want me to write something up on this in case they complain so there's documentation? Okay, 10-4. I'll do that. All right, appreciate it. Bye. Nope, I'm getting him out. All right. All right, don't step out. I'll get those out to you. Check the lot box. Yep, you are the property owner. Again, I didn't know that pulling up, and because of all the chaos of y'all guys screaming at me, I couldn't verify that, okay?
No chaos, sir.
There was a little bit, man.
You drag me like a child.
I did not drag you like a child. I said we're gonna walk over my car, and you wanted to walk over the hill.
You not a rookie.
You're free to go. Have a good day.
You know better than me. That's why you don't do it.
Once the officer has left the world of consensual encounter and entered the world of a Terry stop or an investigatory detention implicating the Fourth Amendment, reasonable suspicion is required. For a lawful Terry stop, a police officer needs specific objective facts, not just a hunch indicating that a crime or violation has occurred. An officer may perform a limited investigatory detention of someone whom he reasonably suspects has committed criminal activity, but such stops can only last as long as necessary to achieve their limited investigatory purpose. And before police officers escalate the situation to this point, again, they should be asking questions. Not just, am I investigating something in my own mind? Or is it my department policy to always get an ID from somebody by force if necessary? You have to think about the Fourth Amendment. Am I involved right now in a consensual encounter, or am I forcing this person to comply with my orders? So if it's not a consensual encounter, what is my reasonable suspicion? What crime am I investigating? Most of these hunch suspicions can be resolved very easily with a consensual encounter. Police may approach anybody really in a consensual encounter and ask for ID or other information, but that person is free to refuse or to walk away unless they are being detained, and that requires reasonable suspicion. That's why the one question that somebody should ask if they're in a situation like this and they're unsure what the legal rights are, all you have to ask is, am I free to go? If the answer is yes, then you have no obligation to provide ID or to comply with anything else. And if the answer is no, now it's been confirmed that the Fourth Amendment has been implicated, it's a detention, and you can comply and avoid arrest while still preserving your rights. Another thing going on
What
here
did I
is
just
the
do?
location that this is taking place. This is sort of a weird scenario. This is a home, but it's a new construction home. Nobody's moved in yet. The inside's not even finished. So is this like an open fields situation, or are we talking about an actual home and the curtilage of a home, where the rules are way different? The U.S. Supreme Court said in 2018 in Collins versus Virginia that the police cannot even enter the curtilage of a home to search a vehicle that's parked within the curtilage of that home, for instance, a driveway, without a warrant, even where they have probable cause. So if that car is sitting in the driveway within the curtilage of this barn dominium, if it gets that protection yet, according to the courts, it doesn't matter whether the officer even has reasonable suspicion or even probable cause. He has to have a warrant. But setting that aside, let's look at what the officer's claimed reasonable suspicion is here. 1, it's a new construction site. 2, it's an occupied vehicle that's parked there. And 3, the guy gets, quote, instantly aggressive and defensive. Also, looking at their police report, they included this fact. During the past year, there have been 121 construction-related offense reports, with many of them being burglaries and criminal mischiefs. Now, that doesn't apply to this situation. That's just sort of like saying this was a high crime area and we were patrolling this area because there have been 100 plus burglaries or crimes that have occurred in that area before. Even including that fact, if true, that's not a whole lot. So, applying that law to all the facts that we just watched, do I think that there was racial profiling involved here? No. In my opinion, it does not appear that the deputy could see who was in that car, whatever race or color they may be. Now, perhaps he profiled the car being an older Honda Accord, contrasted with what looks like to be an expensive construction project. No, this, in my opinion, is yet another example of a police officer's unnecessary, proactive hunch that achieved nothing good, and that, in my opinion, was unreasonable and therefore unconstitutional under the Fourth Amendment. I don't dispute that this police officer did have a hunch. He did have suspicions in his mind. I don't believe that it was nefarious or malicious. He saw something he thought was suspicious, and he did go to investigate. But once he made the decision to turn what could have been just a consensual encounter, asking questions if they want to answer, into a detainment, those suspicions were not reasonable. He had them, but they were not reasonable because nobody had reported that any crime had occurred. He had not observed anything illegal. All he observed was a car parked in front of this construction project. Even if we give that to him, the initial suspicion, even if we say that that is reasonable, it doesn't entitle
Oh
him
yeah,
to just
god
do
damn it, I
whatever
have to
he
wait
wants.
15 minutes.
Remember, such stops can only last as long as necessary. And here, immediately when he started asking questions, they told him they lived there. When he asked for ID, it was provided, and it matched at least one of the two addresses on the front entrance of the property.
He provides me this VL and says 17335. The mailbox says 17335, but the fence says 17327.
And he had that information prior to placing this man in handcuffs, and during the entire 20 minutes or so that he had him in handcuffs. That's just unreasonable in my opinion, and I think many courts would agree with that. And that's not even addressing the elephant in the room. If this new construction house is to be considered a home for purposes of the Fourth Amendment, and if he went in and seized this individual within the curtilage of that house, he had to have had a warrant for exigent circumstances. I looked a little bit into that issue, and it's an interesting issue. Their home is elsewhere on the property. They're building this new barn dominium. It's completely unfinished. At which point would a warrant be required to arrest them within what would be the curtilage of that barn dominium? I think there's a number of factors that would have to be addressed. Whether or not a person would have an expectation of privacy. When you look at those cases, when you look at the curtilage cases in the 11th Circuit, they place a lot of importance on whether or not there is a fence and a gate, especially a closed gate or a locked gate. In the 11th Circuit, in Florida, if you gate your property and you close and lock that gate, and police officers hop over that gate, the case law is overwhelmingly that they have now entered the curtilage and a warrant would have been required. So keep that in mind for the future. Thanks for watching. Please subscribe both here and at the blog, thecivilrightslawyer.com. You can also follow me on X at JohnBryanESQ. And let me know in a comment what you think. I gave you my opinion. Let me hear yours. Remember, our rights don't end where yours do.
What is that?
Freedom is scary.
Oh, one of those things. Hacking time and the living's easy.
Okay. You got some ID on you? I'm just
Da-na-na-na-na-na-na, Ross MD, all the people in the ring gonna free themselves now. Me.
You're a free American citizen. You're traveling in your
Imagine
car.
I am a free American citizen.
It's early in the morning. You're on a busy road, so you pull into a gas station to wait out the storm. You turn your car off, you sit in the back seat, and you read a book as it storms for like an hour and a half. But unbeknownst to you, the cashier
¿Qué pasó?
inside that
¿Qué
gas
pasó?
station is apparently afraid of
Got
the
another
fact
one of
that you
those?
parked there for 1.5 hours, so she calls the cops. You answer their questions.
All right.
They want to obtain your ID because they
Hacking time and the living's easy. Riders on the microphone with Ross MG. All the people in the hood gotta free themselves.
is afraid. That does not limit.
I'm just trying to protect my constitutional rights.
And I understand that, but us asking you to identify yourself isn't a violation of your constitutional rights. It's not, because you're required to identify yourself while we're investigating the nature of the call.
As both a content creator and a lawyer, I take online privacy very seriously, but most most people are completely oblivious to the fact that their private data is being collected and traded online by shady data brokers. Data brokers create shadow profiles on you that include a scary amount of personal details that are then used by corporations, banks, insurance companies, and even the government. That's why I use a product called Incogni that not only tracks down your personal information, but they have that data removed for you. Here's what they've done for me as of today. Incogni has located
This is a cool place. Oh my god.
different data brokers.
I totally need to restore this place.
For 488 of those data
So,
brokers,
what we're going to do...
Now, this would be a difficult and lengthy process to attempt.
Too close
Even
to a
with my
special boss. What? Oh. Is this a boss battle?
I just set it and forget it. Now they're even doing custom removals. If you find some site with your personal information on it that Incogni hasn't already removed, you can submit the link to them and they will remove it for you. So check out Incogni using the link below or go to incogni.com/civil to get an exclusive 60% off an annual Incogni plan. Now let's get back to the video. This is John Cho. He's from New York City. He's a member of the Religious Society of Friends. He was traveling south on February 16th, 2025, and he was planning to worship at the Athens Friend Meeting in Clark County, Georgia. On his way to the meeting, it began to rain heavily, and he stopped at a Murphy USA gas station to wait out the thunderstorm. After parking his car, he read a book called Sky Full of Elephants by Sibo Campbell. This is the actual gas station that he stopped at, Murphy USA gas station in Athens, Georgia, along this busy highway right across the street from a Walmart. John was interrupted by a knock on his car door by police officers who just had to have that record. They had to have that ID.
I'm just stopping for the...
Right as on my phone with Ross and G. All the people in the hood gonna free themselves. Rap it, dap it, dap it, dap it, no bumpy. We na we. Gonna run to the party, dance with the rhythm and get started. Boom, ba doom, boom, boom, ba doom, boom.
Yes, you are. You've been here for hours. I need your ID, sir.
They accused John of being parked there for too long and trespassing, but when he offered to leave, they told him not to leave, that he couldn't leave, that he was being
What is
detained,
this?
and they needed his ID. John refused to give his ID because he believed that he had done nothing wrong. There was no allegation that he had even committed any crime.
Wow.
Do I need to?
I don't know.
Okay, you need to identify yourself. Police provide you your identification.
All the people in the hood gonna free themselves.
If you don't provide your ID, I will.
Just for parking my car?
For trespassing and loitering. You've been here for hours. That's not normal behavior.
Dude, California cops are a lot nicer than this.
I need your ID.
I was parked in a Walmart parking lot sleeping in my car in California once, and they came by, because the Walmart closes, they came by and, you know, knocked on my window. I opened it up and they said, hey, you can't be here. You should probably go check around where the, like around a hotel, or where the truckers drive is what he called it, or the truckers are. So he was nice. He didn't fucking arrest me. He just informed me and guided me to a better option, which is how it should go.
When we're investigating a complaint. Yes, we are. Yes,
All the people in the hood gonna free themselves. Whoa, what the fuck? That is glowy shiny. I think it's another one of those things.
You're going to provide an ID. I'm going to not keep the door open. Okay. I'm going to know who I'm talking to. I just provide your ID.
Do I still have my homing? Okay.
Okay, great.
I'm just reading a book in my car.
So we could have been dealt with this.
If you want to talk to your sergeant, I'm perfectly happy to wait.
I'm not a threat to you guys.
I didn't say you were a
I'm not
threat.
resisting arrest.
The issue is not that we believe you're a threat. The issue is that we're refusing.
Why do they constantly argue with people? Like, even when he admitted that the cops were right, they're still arguing with him. Like, what the hell?
Unsafe to drive during a thunderstorm. Because of the nature of the complaint, and we're out here, you need to provide us with identification.
I understand you're being very reasonable right now. I'm trying to be reasonable as well.
You're not.
I asked
You're
you-
not.
I asked
Is
you-
there a reason?
He is being reasonable. What the fuck is wrong with people?
Of another state, of another jurisdiction? I mean, I think you got. Is this your vehicle?
I'm waiting for your sergeant.
That's fine.
Okay.
And when he tells you the same thing, then what are you gonna do?
He's not gonna tell them the same thing. That's the thing.
If all you need is for him to ask for the
For some reason, supervisors are better people than their lackeys.
I've already told you.
Well, damn it, I want to restore this place.
The issue is the fact that you've
But
been here for hours.
there's a boss nearby, I guess.
So what
Woo!
somebody inside called, they wanted us to check on you. Okay. That's what
So
we're
let's
trying
find
to
this
do.
motherfucker.
They called
It's probably that guy.
We're just now getting here. They said that you've been here for hours. They wanted us to check on you. So because they're wanting us to check on you, that's why we're speaking with you right now.
I'm just trying to protect my constitutional rights.
And I understand that, but us asking you to identify yourself isn't a violation.
See, they're just ignoring the Constitution. What the fuck is wrong with them?
The nature of the call.
That is the supreme law of the land. Constitution.
You could go to jail for that.
Sir, if I'm committing a crime, I'd be happy to give you my driver's license and my ID.
So the crime that you're committing right now is refusing to identify yourself.
No.
That's not a crime.
That's not confusion.
The Nazis in the fucking whatever they're called, Gestapo, said the same things. You're required to identify yourself. Waha! Raindrix stew.
I'm also perfectly have to move. That's okay with you.
And that's what we want the end goal to be, but the issue is that usually when people don't want to identify themselves,
There he is.
underlying factors. That's exactly why, because a lot of times people will have warrants, and they won't want to identify themselves so they don't go to jail. Not that I believe you have warrants, but that's what that usual scheme follows. There's a reason for not identifying.
Your logic is, I'm in my car, and therefore I have a warrant, and therefore you can check my ID. That doesn't make any sense.
It doesn't make any sense because you're misconstruing the order of what I just explained to you.
Alright. You're miscommunicating. You're telling me stuff that doesn't make any sense. I'd like to talk to the supervisor.
And the supervisor should know.
Okay. I'm just doing it from my phone, okay? So okay if I close my phone? Sure.
Yeah, you can close
I'm not hiding anything.
I got you. You can close
I
the door.
don't want anything to get wet.
Okay.
It's okay if I put my jacket on?
Where is your jacket?
It's right here.
Sure.
I'm not hiding anything.
I got you. Hold on, let's not go reaching back into the vehicle. My supervisor just pulled up.
I just got my glasses. I can't see anything.
Sure.
Although it's clear now that John is not from this area, that he was traveling, that there was a thunderstorm, the officer still has to have the ID. Not because of any actual criminal suspicion that had not already been alleviated, assuming it even existed, but he just wants to have that ID because he's probably told that's what his procedure is. When you interact with somebody, you have to get their ID so you can run their names if they have any warrants. Not about crime, about procedure. John wants to protect his constitutional rights, and he requests a supervisor. He's told that a supervisor is coming, But unfortunately, instead of talking to John when the supervisor gets there, he goes up to the passenger window of the original officer and he talks to him first.
What's going on with this guy?
Oh, he's been out here for hours.
What's in the water? Wait.
Oh, I don't know, dude. Because he's been here for hours. The employees like, car's running now, it's not. They've been out. So he's just refusing to identify himself.
Trespassed?
I haven't gotten that far yet. I just want to know who I'm talking to. I'll be talking to somebody who's got a murder warrant, for all I know. He's out in New York. So I'm trying to get something back on the plate, but I'm not sure if that's him or not. So I haven't done anything wrong. Well, maybe you haven't, but you've been here for hours, which is not normal behavior, and now you're just refusing to identify yourself, which makes me really concerned. So yeah, I'm gonna go talk to them about potentially trespassing them, but I was like, let me see if I can find something through the vehicle information, which is what I'm trying to look up now, which
Notice
he's got a...
the name on it was like an Asian name, wasn't it?
Oh, it's an Asian dude, yeah.
He is Asian.
Yeah, so there's a chance. I'm trying to maybe work around it, but he's just really he's...
Is he saying anything about why he's here and what he's doing?
He just said, oh, I'm reading the book. I haven't committed a crime. Well, I'm not. You've been loitering, which is not normal behavior to be here for hours.
Yeah.
So, let me just... I'll go talk to him, but I was trying to at least know, am I talking to somebody who's running from something? It's not... If you're from New York and you're just traveling through, I don't know that that's what he's even doing. He's got a bunch of stuff in his car, like he's... like power cords and everything,
So?
other stuff in there. So you can
The
go
fuck?
look in there and talk to him. I'll see if they want to trespass him, but I was trying to at least... I think it's worth... It's just a red flag when you don't... This isn't a consensual encounter. We're asked to be here because the employee was concerned. I'm going to go talk to her, but I just wanted someone else to be here because I don't know anything about this guy. He's from out of state, which...
Let's see what they want to do, because if they want to trespass him, they need to push him a little harder.
Rather than showing any concern whatsoever for the constitutional rights of this innocent man, the supervisor, before even learning the facts, before even talking to John, he's helping to conspire to jam this guy up. So John has offered to leave. John has not been told to leave by the property owner. The cops have not been told that John has been asked to leave. The supervisor's directions are to go inside and see if they will ask John to leave, so then they can ramp things up.
Let's see what they want to do, because if they want to trespass him, we need to push him a little harder.
And set up an arrest for trespassing or some sort of obstruction charge for not giving them his ID. But it hasn't happened yet. So officer number one then goes inside to talk to the gas station lady who was afraid of absolutely nothing and called the cops for absolutely no reason, creating this entire incident that never should have happened.
Yeah. Okay.
Hey, son.
Good morning, sir. Good morning.
How can I help you today? What's going on?
I don't need any help, but I did stop my car.
Okay.
It was thunderstorm. It was not safe to drive. I was reading my book, and then these officers came and knocked on my door and said I was trespassing. And I said I didn't think I was trespassing. I can move on.
Okay, we got a call here that the car's been sitting here for several hours, and that's why we were called to come out and investigate.
It's been here since it was thunderstorm.
Okay.
I was hoping to ride out the rain.
Okay.
I didn't think I was committing a crime.
Well, I understand that, and if that's the case, that's the case. Like I said, we got a call to come out here and look into it and investigate.
Okay, I understand.
Because they said that the vehicle's been sitting here for several hours. From their perspective,
Yeah.
that's suspicious, right?
Okay, I'm not complaining about that.
Okay. So, I'm just curious, because I noticed you have a New York plate.
Yeah, I'm
You got
from
it. So, are you from New York?
Yes.
Okay. A resident of New York?
Yes.
Okay. What brings you down to Georgia?
Visiting different houses of worship.
Okay. Is there one here in Athens, or are you passing through Athens?
This one, I think it's at Cherokee. Cherokee Corner Church.
Cherokee Corner Church. In Athens, are you familiar with that?
I know
We have Cherokee
Cornerstone
Road and we have
Church.
Cornerstone. I don't know about a Cherokee Corner.
It says Arnoldsville, Georgia.
Oh, okay. So you're a
not
little ways out that way still.
actually in Athens.
Yes, sir. It's in another 20 minutes or so down the road then.
This seems like gaslighting. The Friends Church is actually on this same road, only 5 miles further down the road. Again, this man has answered every question that he doesn't even have to answer. Whatever suspicions this random gas station lady may have been alleviated. Just send him on his way.
Okay. What kind of church is that?
I'm going to a Quaker meeting.
Okay. And you do a lot of the traveling around then? Are you like a higher up member of it?
I'm traveling in the ministry.
Okay.
Just listening to different Quaker meetings.
Understandable. Okay. So again, from our perspective, just so you understand, right?
Yeah.
We don't just show up. We get a call.
I'm not complaining about that. The only issue I had was that your officers kept insisting on me showing my ID, and I said, I'll show you my ID if you're going to arrest me for committing a crime. And that's all. That's where it stopped.
Sure. So what we're investigating right now is we're investigating the complaint of loitering.
Okay.
Right? And that's what we're investigating, and that's why we're out here. So we are investigating the complaint of a crime. We're not just out here because. Right?
Okay.
And we need to determine what's going on. We need to talk to the people in the store and all that. And just quite frankly, like whether you're in trouble or not, right? As soon as someone says that they don't want to show us, that they refuse to show us an ID, it's a red flag for us.
Okay.
Right. It's us in a lot of cases, and I'm not saying it's you specifically, but a lot of people are trying to hide from something. And the easiest way to move on and clear it up, because you've got nothing to hide from, you run your name, it comes back clean, and we all just move on, you go to church, and we leave the gas station and everyone's on their way.
Okay.
Right? And it's simple enough as that. Because otherwise, the loitering complaint, then it only furthers our suspicion that there's something weird going on and that there's a problem of some sort.
Yeah.
Right? And so that's part of our investigation.
I tried to explain to officers that I only stopped because of the rain. I had to move on. I was just reading my book when you knocked on the door. I was doing anything illegal. As far as I know you're saying that I'm trespassing, but I didn't realize I was trespassing.
And we understood that, which is...
Morning. I don't know. He's being difficult. Do you want a barn? He's coming from. He's not even from here. He's from New York. So I don't know what he's got going on.
What the hell is going on with them? Oh, he's not from here, so we gotta watch him in case he does a crime.
Yeah, no, that's not normal behavior. I agree.
Oh my god, this is a free country. There's no such thing as normal behavior.
Yeah, no, I get it. That's you tucked in the corner. It's like that's how things. I get it. You can. It's up to you.
Da na 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 na. Da na 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 na.
I don't know this guy. He's not.
Da na na. Being from another city is not a crime.
It's a crazy world we live in.
No, you're the fucking crazy one.
Yeah, they want a barn.
You want to borrow?
Yeah.
Try to explain to you the nature of our investigation.
So here's the thing, sir. They want to bar you from the property. Okay? That's on them. That's their right to do. So in order to do that, at this point in time, it is a criminal trespass warning. Okay? It's not an arrest. However, it is something where we do need your ID so that we can fill out the paperwork and officially make it that you are barred from this property. Okay? So at this point in time, because they want to do that, we are going to need your ID.
He'll just come up with any excuse to try to get his ID.
So I parked my my car here in the rain. They called you, I don't know exactly when, but when you guys arrived, you asked my ID. I refused to give my ID because I didn't believe I did anything wrong. But now you went to the manager or whoever this person is, and they are asking for a bar. I just trying to explain.
The trespassing is on the property.
Warning. So what they're doing is they are barring you, they are trespassing you from the property. If you return back here, then you will be arrested for trespass. Okay? And so for that process, you will need your ID. Okay?
So just so I understand, they're asking you to leave.
No, they're telling you you're not back allowed on this property. They're making an official report and documenting that you're not allowed on this property.
Okay, I haven't been here before.
It doesn't matter, sir. No, you keep on trying to string it along.
You're trying to understand that we're explaining to you the process.
And you just keep on going and
keep going back to the point that we've already explained.
He's trying to understand it, guys. You help him understand it. You don't, like, play Big Brother and make all these assumptions and Jesus.
And we move on. And that's that. That's the end of it right there. Okay?
Sir, I was not planning to come back here.
Okay.
So,
okay, but we have...
On June 2nd, 2014, the Florida Bar filed a disciplinary complaint against 3 Tampa attorneys at the law firm of Adams and Diaco, equity partners Stephen Diaco and Robert Adams, and non-equity partner Adam Filthouse. The complaint arose from events that took place during the firm's representation of radio personality Bubba the Love Sponge Clown in a civil suit brought by rival radio host Todd Schnitt. And Mr. Filthouse, along with Mr. Diaco and Mr. Adams, were alleged to have participated in a scheme to have Mr. Schnitt's lead attorney, Philip Campbell, arrested for driving under the influence. Following a disciplinary trial, the referee appointed by the Florida Supreme Court recommended that all 3 attorneys be permanently disbarred. Now, Mr. Diaco accepted the permanent disbarment, but Mr. Adams and Mr. Filthouse appealed the recommendation. Oral argument was heard on June 9th, 2016, with attorney William Jung representing Mr. Adams, Mark O'Brien representing Mr. Filthouse, and attorney Jody Thompson appearing on behalf of the Florida Bar. Mr. Jung presented his arguments on behalf of Mr. Adams first.
The next case on the docket will be the Florida Bar versus Robert Adams. Whenever you're ready.
Mr. Chief Justice, and may it please the court, I'm William Jung, and I'm here with respondent Mr. Robert Adams. We're here on a very narrow grounds. The sole issue presented by our appeal is the finding of permanent disbarment. We do not contest the findings of fact. We do not contest disbarment. And we don't contest any of the findings.
What?
I might call the convictions on the recommended findings of discipline. The issue presented here is simply whether permanent as opposed to non-permanent disbarment is appropriate. As Mr. Adams did below, he comes here and confesses his serious, egregious, ethical shortcomings.
Well, wait a second. What do you say he did it below? I thought it went through a full hearing by the referee.
Yes, it did.
And I didn't think he only testified at the very end. So when did he confess how egregiously wrong the conduct was?
Your Honor, I believe his direct testimony from the stand was that he has never committed such error in judgment in his 47 years on this planet Earth.
Well, I would hope not. I have never, and you know, I don't profess to know everything about the law, but I have never encountered, and I've been in some rough situations, I have never encountered behavior like this, and calculated and planned behavior. This is not a, okay, I made a mistake. You know, I shouldn't have signed that check. This was a planned, even planned at one time, and it didn't reach fulfillment, and then did it again, or did it, and then even took the files, this law firm. Took the opposing lawyer's files in the briefcase, didn't they?
Well, Mr. Adams wasn't specifically involved in that, but I'm not here, and he instructed me to come not to defend him or to venerate him.
Well, yeah, but
his
you're saying this is just some kind of simple circumstance. This is not simple.
What I'm suggesting and why we are here is because this court's jurisprudence on disbarment versus permanent disbarment suggests that simple disbarment, which is far from any guarantee of readmission, and in fact, as the court knows, the presumption is against readmission should there be an application sometime after 2021. The presumption would be against readmission, but the referee's recommendation of permanent disbarment is inconsistent. I'm here to venerate the court's guidance and the court's precedents, which do not support permanent disbarment.
Well, you know, it could be we've never seen a case this bad.
Well, Your Honor,
Is that possible?
Your Honor, I would suggest the cases that we've cited are not as severe as the conduct that occurred with Mr. Adams, as opposed to his main partner, Mr. Diaco, on the case. First of all, the first time they called the police on opposing counsel, Mr. Adams was out of town, knew nothing about it till after. I don't believe Personis was involved in any way. She encountered opposing counsel perchance in a bar, and then she called Mr. Adams. Mr. Adams spoke to Diaco, who said, call Heatlh out. Heatlh out was friends, co-respondent and friends with the police officer.
So he knew, I mean, again, there's no question, he was intimately involved with the setup to try to get this lawyer arrested.
He was involved.
And he knew the lawyer was a lawyer in a hotly contested case, right?
Yes. Disbarment.
Oh, I gotta wait 15 minutes. That's right.
And that's why the bar.
So let's go find this tower.
Said rehabilitative suspension to the referee because of that.
When you say rehabilitative, what are you talking?
The bar agreed to a 91-day suspension for Mr. Adams.
At what point?
At the conclusion of all discovery.
But not before it went to trial.
Then the referee said no. There was massive publicity caused primarily by Mr. Diaco's inflammatory statements. The referee said no. We went to trial. He convicted Mr. Adams on everything, and the bar then said what I'm saying right now, disbarment not permanent for Mr. Adams, because he was not involved, had no connection to the police officer, didn't know him.
But the problem I see with your argument is that Mr. Adams is the one that the paralegal called on the important night, correct?
She did, yes.
And he knew what had gone on 2 months before, correct?
Correct.
Even though he didn't know beforehand, but he knew after the
yes,
fact
ma'am.
What had gone on 2 months before, and then he made the conscious decision to call them and tell them that he's there now.
To call Diaco.
What did he expect to happen from giving that information?
Your Honor, what I would expect him to happen is he would be disbarred. He would be disbarred like many other lawyers. Heatlh Bailey, who stole from clients and forged judges' signatures, disbarred without permanency. Like this other series of cases where we've seen where someone who makes a horrible mistake is not permanently disbarred. And I've cited the cases, so he should be disbarred. But he should not be disbarred. The permanency cases, and the referee never discussed these. He's not like Norkin, who showed up here and smirked and stared down Supreme Court justices at a public reprimand and was permanently disbarred. He should be entitled to have a chance to be rehabilitated in 5 or 6 years with a presumption against readmission. Thank you.
Later that day, Mr. O'Brien presented his arguments on behalf of Mr. Heatlh, with Ms. Thompson once again appearing for the Florida bar.
Movie Barr versus Adam Heatlh. When are we ready?
May it please the court, my name is Mark O'Brien. I represent Adam Heatlh. Your Honor, we raised 5 issues before the court on our brief. I'd like to start with the 5th, which is that permanent disbarment is not warranted in this case. As the court in the previous oral arguments started to understand, there are different levels of culpability within the actions of the participants in this case.
Just bring me right to the fact that it sticks out in my mind is that it is your client who knew the police officer, correct?
For 15 years.
And it's your client who got in touch with the police officer, both in the first instance and this instance, to get the police officer to survey or keep an eye on or let him know when Mr. Campbell was either driving drunk or something. Correct? Is that not correct? It was your client who got in touch with the police officer on both occasions?
Yes.
And the police officer lost his career, am I correct?
That is correct.
High price for everyone to pay for this act. Don't you agree?
Without question. Without question.
There also, under the injury, not only the wrongful arrest and incarceration, the disruption of an ongoing jury trial, the discharge of Fernandez, removal of Officer McGinnis from the DUI squad, dismissal of a significant number of pending DUI case. Are all those correct as far as the injury that resulted from the attempt to gain an advantage in an ongoing trial?
That is factually accurate, as to what the court just stated. What I'd like to point out is that we have an instance where Mr. Heatlh would not have been involved in this, but for the fact that he was very close friends with the officer, Sergeant Fernandez.
Well, that makes it, I mean, but I guess, but for, and I don't know what the testimony was, they obviously had this contentious litigation. Mr. Heatlh was not involved in the litigation, but they must have known, he knew, that Mr. Campbell was a thorn in their side in this high-profile case, correct?
I would suggest to the court that Mr. Campbell and Mr. Stephen Diaco were professionally not fond of each other. I would suggest to the court that Mr. Heatlh, in his role as a subordinate, was told to do something by his supervisor on 2 separate occasions.
Are you saying that Mr. Diaco knew about the friendship that Mr. Heatlh had with the police officer?
I think that's undisputed by both
parties. It was a personal friendship?
Personal.
And it was Mr. Diaco that he instructed. So it wasn't Mr. Heath's idea to try to entrap Mr. Campbell?
No, absolutely not. And I don't believe either party will dispute that.
Okay, but he's, at the time this happened, your client had been a lawyer for how long?
At the time, I believe 13 years, 16 years currently.
Been a public defender for a couple of years?
Several years.
He clearly knew, did he not, even the first time, that this was totally flagrantly wrong, what he was trying to do?
Well, I think that let's take the first instance back in November. My client, Mr. Heatlh, his sole involvement in that first instance with Mr. Campbell was making one phone call, period.
But the intent, what was the intent?
Well, I can tell you on behalf of the respondent, his intent was as a citizen informer to...
He didn't testify. How would we know what his intent was? Did he go around? Was he like a pal of Fernandez going around because he really had a thing against DUIs and trying to make sure that anybody that was in a bar, would not drive and drink? I mean, come on.
Sergeant Fernandez testified that Mr. Heatlh had given him tips on several occasions regarding drunk drivers. Now, Sergeant Fernandez did not testify at the trial. He invoked his Fifth Amendment right, but he had, as Bar Counsel stated in the previous oral argument, given additional earlier testimony in separate proceedings.
Mr. O'Brien argues that Mr. Heatlh was acting as a citizen informant on the night in question, not as a co-conspirator. On the evening of January 23, 2013, while the Bubba the Love Sponge trial was in recess for the night, a paralegal from Adams and Diaco, Melissa Personius, happened to encounter Mr. Campbell at Malio's Steakhouse near the courthouse. After Ms. Personius alerted Mr. Adams to Mr. Campbell's presence at the bar, she returned to Malio's.
Hi, Dada B.
She flirted with Mr. Campbell, lied about where
Hey,
she was
sweetie.
employed, encouraged him to drink, and even bought him drinks. Meanwhile, Mr. Heatlh contacted his personal friend, Sergeant Raymond Fernandez of the Tampa Police Department, at Mr. Adams's request to alert him that Mr. Campbell might soon drive while intoxicated. According to Mr. O'Brien, Mr. Heatlh's conduct was distinct from that of the equity partners, as he simply called his friend at the Tampa Police Department to report a potential drunk driver, just as he had done on several prior occasions. As such, Mr. O'Brien argued that Mr. Heatlh was not conspiring.
I love you,
against
baby
opposing
girl.
counsel, but passing along information about a potential
I love
impaired
you so
driver to law
much.
enforcement.
It seems to me
My
every
girl.
lawyer takes an oath, correct, in this state.
Yes.
And every lawyer is charged with knowing the ethical rules.
Oh, bye-bye.
Yes.
Oh, where's my
each
precious
looker
girl?
has an obligation to protect
I
his
love
or
you,
her
banana.
license.
Yes.
Correct? And so whether Mr. Philpott was told by Mr. Adams
baby.
or Mr. Diaco
Do you want to come up here?
to do something unethical,
Do you want to come up here?
had to make the decision
You can.
about whether or not he was going to participate.
Did you want to play string?
Unethical, didn't he?
Huh?
Yes. And so it seems to me that
Where's your string
the
at?
fact that it may not have been his idea, the fact that they knew he had this relationship with the police officer does not negate the fact that he chose to participate in a totally unethical scheme.
And that's why I began with the fifth issue and not the first. The fifth issue is whether or not permanent disbarment is warranted. I would suggest to your honors, it is not when you look at the actions of each individual that evening, and more importantly, into the next day.
Was he also a part of all the texting and things that went on that night? I mean, I thought there was like 17 or 18, maybe even 19 different texts between the paralegal and your client.
Judge, I would submit to the court that in candor, there were more. But I think it's important to point out when you talk about the text messaging and the phone conversations between Mr. Philtout and his best friend at the time, Sergeant Fernandez. Sergeant Fernandez has previously testified under oath that a large majority of that conversations related to totally innocuous conversations about paintball, their children, there's a godfather relationship.
Because what happened to your client's cell phone?
I'll tell you exactly. I'll echo Mr. Jung. What happened is Mr. Diaco hired a third-party lawyer, Lee Gunn, took possession of all of those cell phones, and that's the extent of the respondent's knowledge of his cell phone. He was ordered to give his cell phone to Stephen Diaco, who then provided all of the cell phones, including the respondents, Ms. Personius, Mr. Adams, to Lee Gunn. And that was done, I believe, at the direct consequence of Judge Arnold's litigation or Clem Schmidt litigation due to the spoliation letter that Shoemaker Loop served on Adams and Diaco. And that's important to note that Mr. Philtout is often described in the media accounts and even in this trial as a partner. He's not. He is, for lack of a better term, an associate attorney. He is a non-equity partner.
I'm not sure for this situation that matters. And I know we'll look at your other issues, but is he at all involved in the briefcase?
Zero.
Okay. Not involved in any of the public statements?
Zero. Whom are you?
Okay. And was the bar has brought up additional aggravation with a PIP lawsuit in Miami. Anything on that?
Zero involvement.
No other prior disciplinary proceedings?
In 16 years, he has zero other, and it's important to note that he was a public defender, which when you serve in the criminal justice aspect of being a lawyer, especially as a public defender, you're often dealt with unhappy clients. My client has never, ever faced any disciplinary proceeding as a result of any of his years. 16 years as being a lawyer, which I think is very important.
Mr. O'Brien emphasizes that Mr. Philtout has never faced previous disciplinary action. Under the Florida standards for imposing lawyer sanctions, which is the framework the Florida Supreme Court uses to determine the appropriate discipline for attorney misconduct, the absence of a prior disciplinary record is a recognized mitigating factor. Standard 3.1 proves that once misconduct has been established, aggravating and mitigating circumstances may be considered in deciding what sanction to impose. And Standard 3.3 defines mitigation as any factor that justifies a reduction in the degree of discipline to be imposed. The list of recognized mitigating factors in Standard 3.3 expressly includes the absence of a prior disciplinary record. By focusing on Mr. Philtout's years of practice without any prior discipline, Mr. O'Brien seemed to be presenting his client as someone who engaged in a single, isolated lapse, rather than a career-long pattern of unethical behavior.
With regard to the phone, the trial judge determined that at trial, both respondent Diaco and respondent Philtout refused to answer any questions about the destruction of their cell phone messages and are subject to the adverse inference that they too have deliberately destroyed. Did the trial judge find that?
Yeah, absolutely, sir. And just to follow up on that, there is evidence that Mr. Adams, through his own testimony at the trial, said that he deleted text messages. There is evidence through Melissa Personius' own testimony at a separate proceeding that she deleted text messages. There is evidence that Mr. Diaco took those phones and gave them to Attorney. There is zero evidence, that Mr. Filtout deleted a text message, destroyed his phone, did anything other than what he was ordered to do by a supervisor, presumably pursuant to a spoliations letter that was sent by opposing counsel in the Clem Schmidt case. I don't believe there's any evidence to support, Your Honor, that Mr. Filtout... I'm sorry? Yes. And I say that respectfully.
You're into your...
I'm sorry?
Is that an issue here? Is that one of the issues that you've raised, that there was no...
It is.
Substantial competent evidence to support that finding?
It is. If you look to issue number 4, that the referee's findings are not supported by competent substantial evidence, there is no evidence that Mr. Filtout deleted any text messages or destroyed a phone. There simply isn't. There is a negative inference that the judge makes and uses that as the evidence, and I...
Ooh, pretty little village.
Negative inference alone
Yeah.
is not enough. That there needs to be something else. With respect to the other participants, I'd submit that there is. With respect to him, there isn't.
Well,
so I believe that
but
that's
basically, the 19 texts or more texts, you fully admit that the incident, that but for Mr. Filtout and his knowledge and friendship with Fernandez, the ensnaring, the entrapping, the unethical conduct of that night would not have occurred. So whatever the text, I mean, I don't know how much worse the text could have been, but unless there's some other conduct, I'm not sure what the additional negative
Oh my.
from the text messages. So I guess I'm sort of a semi-friendly question. What did the judge draw as a result of finding that he had destroyed his cell phone?
Well, the judge ruled two different things. Number one, that he conspired with other people, and then he ruled that Mr. Filtout covered up that conspiracy. And I just suggest to the court that there is zero evidence that he covered up any conspiracy. He didn't, because there's no evidence that he deleted text messages. There's no evidence that he destroyed a phone. In fact, to the contrary, there's evidence through Rob Adams' testimony at trial that Stephen Diaco took those phones and gave him the lead gun. So I think that that's fairly clear, and I submit to the court that the referee simply got that wrong, and I say that respectfully. As to issue 1, I do believe that the respondent was denied due process when the referee denied his motion to disqualify the referee. I do believe, as to issue 2, that the referee erred in denying summary judgment. As to issue number 3, I do believe the referee improperly relied on facts not in evidence. And as to issue number 4, again, we believe the referee's findings are not supported by competent substantial evidence.
But you do agree that if you get through that you're not contesting disbarment, or you are? Are you arguing for a lesser penalty than disbarment?
I'm arguing that this individual have an opportunity at some point in the future to reapply for his license to practice law.
Okay, so you're agreeing to, even with all these, unless we found the judge should have recused himself, that it should be disbarred.
I started off with number 5.
Okay.
And I did so for a reason.
Thank you. Mr. O'Brien explains that he is not arguing against disbarment, but that Mr. Filtout should have the opportunity to reapply for a law license at some point in the future. Under Rule 3.5.1 of the rules regulating the Florida Bar, a disbarred attorney who has not been permanently disbarred may apply for readmission after a minimum of 5 years or a longer period if specified in the disbarment order. On the other hand, Rule 3.5.1 expressly provides that an attorney cannot file an application for readmission after an order of permanent disbarment. However, as the Florida Supreme Court explained in the 1966 case of the Florida Bar v. Carlson, permanent disbarment is warranted only where an attorney's misconduct indicates that they are beyond redemption and cannot be rehabilitated. Accordingly, Mr. O'Brien's position is that although Mr. Filtout's conduct warrants disbarment, it does not rise to the level of requiring permanent disbarment, and that Mr. Filtout's ability to apply for readmission after a period of time should be preserved. Once Mr. O'Brien had completed his argument, Ms. Thompson presented for the Florida Bar.
Mr. Filtout was the ingredient in this conspiracy that made it work. Without Mr. Filtout's personal, close friendship with the law enforcement officer who trusted him and didn't have a suspicion of what was going on, this would not have happened.
Let me ask you, but here's my question, and it's, we've got one defendant, respondent that's agreed to permanent disbarment. Another was involved in the briefcase incident, which is outrageous to my way of thinking, and also made public statements which revealed the motivation in this and was involved in that lawsuit and was a partner. We have criminal cases, and you look and say at the end when they're sentencing, you've got 3 defendants. Sometimes we talk in proportionality about equal culpability. I think in the eyes of the law, clearly he's equally culpable for what happened that night.
Oh,
and the
that's
setting
my
up.
that's my castle.
In terms of the ultimate sanction, that everybody gets the ultimate sanction so that this will never happen again. The word is it will never happen. But isn't there some distinction between what Mr. Diaco did as the partner involved in litigation and Mr. Heatlh, and if not, just, and again, I'm trying to understand that. And right now, appreciate the candor that everyone is agreeing their disbarment is appropriate. So could you explain why, you gave us some reasons for Mr. Adams, why for Mr. Heatlh?
Yes, Justice Pariente. Mr. Heatlh never testified in this case. He had the opportunity to. He had the opportunity to even hear Mr. Adams' testimony, think about it overnight, and yet he still stood firm and refused to testify, to stick together with the co-defendants. Mr. Heatlh should not be...
Are we allowed to draw, because this was an ongoing, and I think that the exercise of his Fifth Amendment right, we can, based on that exercise, draw an adverse inference, that he's entitled to no mitigation. But what's the not testifying? Does that mean he's showing no remorse? What is the significance of that here?
Yes, the significance to the bar is that if Mr. Heatlh is allowed to have a lower sanction, he's being rewarded for failing to be forthcoming, to failing to have candor, to invoking his Fifth Amendment. He should not be rewarded for that behavior. There was a lot of aggravation, not just his personal relationship, dishonesty during the disciplinary proceedings.
I guess the bottom line of this whole thing, where you have this groupthink, where this happened. What happened to the old maxim? A lawyer sees this happening and says, I can't do this. This is wrong. I'm out of here. I mean, quit your job, whatever. I'm out of here. I'm not doing this. Whatever happened to that? I mean, I'm just wondering.
Justice Labarge, I take it that that's not just a rhetorical question, but yes, that is exactly the point. All of these attorneys conspired together and committed these acts willingly, knowingly, intentionally for a bad purpose.
Hearing is, this guy did this guy didn't do that, this guy talked, this other guy didn't. They're all in this together. And the whole purpose of the whole thing was to damage this other person's reputation, one way or the other, and in there somewhere there was some advantage that they thought they would gain from this. But again, people are talking about doing something wrong, something bad. You're a lawyer. You took an oath. I can't do this. And if it means, hey, I'm not going to be getting a paycheck from this firm tomorrow, fine. Go back to the public defender's office, go to the state attorney's office, whatever. But we don't do this. That's the whole thing here. When I'm talking about who's more culpable, they're all culpable.
I agree with you, Justice Labarge. It's been said that character is who you really are when nobody's watching. And in this case, the respondents, both Mr. Adams and Mr. Heatlh, their conduct shows that they have bad character and they should not be allowed ever to practice law again. It's also said that character is who a person really is, but reputation is just who other people think the person is. And even though the respondents had put in as mitigation that they had character evidence in their reputation and the good deeds they had done, that is not enough to overcome the severity and the horrible nature of this. And anything less than permanent disbarment, I would argue to this court, will not be a sufficient deterrent to other attorneys to dissuade them from engaging in similar behavior.
Ms. Thompson argues that any penalty less than permanent disbarment would be insufficient to dissuade other attorneys from engaging in similar behavior. Rule 3.4.3 of the rules regulating the Florida Bar states that a lawyer may be disciplined if they commit an act that is unlawful or contrary to honesty and justice. In this instance, the referee concluded that Mr. Heatlh violated this rule by actively conspiring to improperly effect Mr. Campbell's arrest. Here, Ms. Thompson asserted that conduct of this nature reflects a fundamental defect of character rather than a momentary lapse in judgment, and therefore, the sanction imposed must reflect that gravity in order to deter other attorneys from following the same path. As the commentary to Standard 1.3 of the Florida Standards for Imposing Lawyer Sanctions explains, one purpose of imposing sanctions is to educate other lawyers in an effort to deter unethical behavior among all members of the profession. Ms. Thompson's position is that in a case like this one, only permanent disbarment is sufficient to prevent other lawyers from acting similarly. Following Ms. Thompson's argument, Mr. O'Brien was given the opportunity to address the court in rebuttal.
Picking up on that last point, at one point the Florida Bar felt that 91 days was enough to deter other attorneys from this type of behavior. After the trial was over and the respondent was found guilty, the Florida Bar felt that non-permanent disbarment was enough to deter attorneys from this type of behavior. Now all of a sudden it is permanent disbarment. I would suggest to the court, and Mr. Chief Justice, I will answer your question because I believe it's very important to you, and that is an individual can be as guilty as someone else, but that doesn't mean that their punishment must be the same as someone else. There are different roles in the actions of multiple individuals, and because there are different roles, there are often meted out different punishments. Some are higher than others, some are lower than others. When you look at, and I say this not to besmirch anyone, but you have Stephen Diaco over here with the trial bag and the statements to the media, and anything that he did that night, he was involved with everyone. He had contact with all the parties. Then you had Robert Adams, who falls below Mr. Diaco. And then at the far end of it, you probably have Mr. Matroni, who was determined by the Florida Bar to be acting at the direction of his supervisors. I'm not telling you that Mr. Heatlh is right next to Mr. Matroni. I'm simply arguing that he's not close to Mr. Adams and Mr. Diaco. He's somewhere in the middle. And as a result, I think his punishment should be less than those two individuals, but greater than Mr. Matroni. It's important to note that his only involvement in this is but for the fact that he knew Sergeant Fernandez. Don't you think that was known by the individuals in this case? Don't you think that there's a certain amount of manipulation that was done by Mr. Diaco with everyone involved? And
that's all well and good, but your client is a member of the Florida Bar and had been for over a decade at the time this took place. And he had, as the Chief Justice just said, he could have walked away from this, but he stayed in the mix twice, and I just don't see how he's not as culpable as the others.
Madam Justice, I don't dispute that, which is why I'm not asking for a letter that goes in this file or a suspension of 10 days or even a suspension of 91 days. What I'm asking for is a punishment that essentially meets his involvement in the crime. I'm not talking about culpability.
But the reality is there's not an unlimited range of punishment. I mean, the worst we can give is the permanent disbarment. So the fact that someone did something worse and only can get permanent disbarment, that's just a kind of part of the structure of reality that we're faced with. Now, perhaps if something more could have been done, it would be done, and because there is an extra element of culpability. But we have limited tools available to us. So the question is, though, ultimately, for your client, is this sanction appropriate?
And I would suggest to the court it's not, because what you have is, like as you said, a limited amount of options before the court. And if you're going to assign the worst punishment to the worst actor, that's appropriate. At that point, then you go below. It's like that in the criminal justice.
See, I just don't buy the logic of that, because sometimes people that have been involved in may not be the most culpable are still eligible for the highest sanction that we have available. I don't follow the logic of what you're saying.
And I understand that. I'm simply arguing to the
I
court.
understand it's an argument.
It is our position that he is deserving of a less punishment than Stephen Diaco, and to the extent that perhaps
I am
Mr.
so
Robert
sorry.
Adams. I would also suggest to the court, just going back to the...
You're well over.
Oh, well, then I will suggest to the court I will sit down.
5 minutes there.
Thank you.
Thank you. Okay, the court's in recess. Thank you for your arguments.
On August 25th, 2016, the Florida Supreme Court issued an opinion approving the referee's recommendations in full and permanently disbarring Mr. Adams and Mr. Heatlh, describing the attorney's actions as, and I'm quoting, among the most shocking, unethical, and unprofessional as has ever been brought before this court. In addition, the court entered judgment in favor of the Florida bar against Mr. Adams for the recovery of costs in the amount of $14,558.66 and against Mr. Heatlh for the recovery of costs in the amount of $14,178.28. This case is a reminder of the foundational role of ethical conduct in the legal profession. The practice of law depends on the trust of clients, the integrity of adversaries, and the confidence of the public in the administration of justice. When an attorney engages in conduct that's designed to manipulate the legal system for personal or professional gain, the harm extends well beyond the immediate victim. It corrodes the trust that allows courts to function, it undermines the willingness of citizens to engage with the legal system in good faith, and it damages the reputation of every other attorney who works honestly within the rules. The Florida Supreme Court's decision in this case reflects the principle that ethical violations of this magnitude are not technical missteps to be corrected to a brief suspension and then a return to practice. Rather, they go to the core of whether an attorney can be entrusted with the responsibilities of the profession at all. Let us know if there is a case or courtroom interaction that you would like us to explore in the comments below. Thank you for watching, and don't forget to like and subscribe so we can help foster a more informed society.
Sheriff's Department, whoa. Wake up, man.
Body cam footage you are about to see has never been seen publicly and caused the feds to indict a West Virginia police officer. When that went to a criminal trial, the jury who saw it found the officer not guilty.
Sheriff's Department, man, wake up. Don't be swinging. I'm gonna put you in handcuffs.
This is some of the most disturbing police body cam footage that I have ever seen.
There's the solution. Do you like that solution? I got that problem solver, man. I got that problem solver, huh? It's caliente, man. Mucho caliente. Now, could you calm down so I can fix my tie, sir? Now look at that. I'm all disheveled. Stop, boy! Stop! Boy! We do this all night, man. Do this all night long. Stop stepping on me. You awake? Rise and shine. Sit. Yes, sir.
Let's pretend that you are a jury. I'll show you the evidence. Give me your verdict. I want to thank all of you for celebrating with me passing the 1 million subscriber mark. It's nice to get nice messages. Earlier this month, though, I got a really hateful message just out of the blue. Apparently, it came from a family member of a police officer that I did a video on back in August of 2022. It was about a West Virginia deputy who was arrested and indicted by the feds. And at the time, I could not show the body cam footage. It was not available anywhere on the internet because it was being used in this prosecution. I sent a FOIA request for it, but it was denied, as I detailed in that video over 2 years ago. After reading this hate mail that I recently received that said, "Get your facts straight," that said I lied, that called me a fraud and a fake lawyer and a punk, and told me to go myself, loser, and it included part of a story about this same police officer being found not guilty ultimately in his criminal prosecution. So I responded to this guy, "That's right, I remember this case, thanks for reminding me. Now that the criminal case is over, I'll send another FOIA request." Well, just a couple of days ago, I got that footage in. Was this deputy completely innocent? Was he the victim of A tyrannical federal government prosecuting him for political reasons? Let's look at the footage together. I'll try to be fair, and you can reach your own conclusions. This incident occurred in Monongalia County, West Virginia. That's where WVU is, up closer to Pittsburgh. These are the facts of what happened according to the U.S. Attorney for the Northern District of West Virginia. Deputy Lance Carezza and 6 other police officers responded to a disturbance at the Residence Inn Hotel on January 20th, 2018. An investigation at the scene determined none of the suspects broke laws or would be arrested, but hotel management asked that they be escorted from the property.
We don't have any probable cause for an arrest. You're gonna be packing your stuff. We'll be waiting for you. We're trying to stop you guys from getting arrested. If we tell you don't go in there, don't go in there. Okay, to be quiet, be quiet. We're trying to figure out a way to get you guys out of here so nobody gets arrested.
Liar.
As the group exited the floor, Carezza ordered one of the guests to open the door to a nearby room where he found a man sleeping. Carezza then allegedly began to shake the man and hit his feet to wake him up. When the guest explained he was sleeping, Carezza threw him off the bed and beat him. As the
Oh my
contact
God.
escalated, Carezza restrained the guest as the 6 other officers were in the room. This particular victim had a flashlight in his face and thought it was his friends just messing around with him. It turned out it was a sheriff's deputy, and from there, it got really out of control. Carezza battered and used pepper spray on the victim while the victim was handcuffed. Then, while the suspect was being taken out of the property, Carezza allegedly continued to use unnecessary force. Then, the police report that was filed after this happened did not indicate the pepper spray had been deployed after handcuffs were put on the victim. In fact, it said that pepper spray was deployed before handcuffs were used, which was not consistent with the video evidence that we have. Now, this is the narrative that Deputy Lance Carezza wrote in his report. Deputies were advised that there were multiple males fighting and there were threats being made to shoot someone. Upon our arrival, we made contact with 2 rooms of males in various states of intoxication. I made contact with a male later identified as Quentin Graciano, who was lying on a bed inside one of the hotel rooms. I announced myself several times, but Graciano refused to get up. I attempted to shake Graciano awake, and he pushed me away. I eventually was able to wake Graciano fully, at which time he struck me with his fist. Graciano then rolled out of the bed in a physical confrontation. Here's the action.
Sheriff's office. What? Would y'all step out for me? Sorry, sir. Take your hands out of your pockets. Step out here. Hands out of your pockets. Yep, sorry, sir. There you go. Sorry, sir. Step out here. What's going on tonight? Step out. We're trying to keep your hands out of your pockets. I'm not going to tell you again. Step outside. Hands out of your pockets. I don't know how many times I have to tell you. Stop moving. Do you understand me? Keep your hands out of your pockets. Out of your pockets. Okay. Fine. Do you want to sleep off, sir? I'm good. What's going on with you?
Oh.
What's going on? Something's going on here because we're here. What's going on?
You mean I'm in this hotel room.
Okay, was there an argument or a fight? Nothing?
No.
Give me your ID.
You can have it. Yeah.
Okay, they just said that there was a fight, so what's your malfunction?
What?
No, I said
Oh
what's
my
your
God.
malfunction, because they're all admitting that there was a fight.
You can ask them, I don't know.
They did ask them, I'm asking you. I asked you if there was a fight, and you said no.
As far as I know,
You're sitting here and there's 6 big fights in the room, and you have no idea what's going on. You're being very unhelpful, very uncooperative.
1,000% yes.
1,000% yes what?
1,000%. Yes, if there was a fight, I was here for it, unknowingly.
You're that drunk?
No, I was here.
Stop talking.
My body corrects, laying down, he's laying there, so
Go. Damn, this place. Oh my God.
Yeah, it's me. That's my bad.
Keep your hands out of your pockets.
Anyone else report? Okay, who's in 3.7? Which one? The one that you're I have both. So, stand up, man. Sit by here.
Nope. Yep, come on out.
I probably have a key to that. I'm with them. Okay, let's see if you got a key. So, but no, you said you got.
Does anybody have a gun? Their gun. Has any of you guys not been drinking?
By the way, if you're asking yourself, well, wait a minute, can cops just go into hotel rooms? Do they need a warrant for that? If you're asking yourself that, you're completely right. Apparently, this was not even part of the criminal allegations against Deputy Carezza. In West Virginia, we are in the Fourth Circuit. The Fourth Circuit, consistent with U.S. Supreme Court precedent, Stoner versus California, 1964, recognizes that a hotel guest has a reasonable expectation of privacy in their hotel room during their stay there, during their tenancy, just like it's a home. But what if the hotel management gives the cops permission and says before the mile they need to go? Well, hotel management cannot consent to a police search of a guest's room while the guest retains a privacy interest in the room. Only the guest can waive their Fourth Amendment rights, absent some other exception. So this expectation of privacy in our hotel rooms can only be terminated when the guest's rental period ends, i.e. checkout time, or when the hotel evicts the guest for valid reasons, such as disruptive behavior, and takes affirmative steps to repossess the room. For example, locking the guest out or notifying the guest of eviction. Here, while we're told that the hotel wants them to be allowed, we see no proof that hotel management has asked them to leave and they've refused. We see no proof that hotel management has taken some sort of affirmative step to lock them out of the room or evict them from the room. Certainly in the middle of the night here, this was not their checkout time. The other exceptions that might allow the police to enter these hotel rooms under these circumstances would be exigent circumstances, such as immediate danger to others or destruction of evidence. Or there could be voluntary consent to enter by the guest. But here, since we're dealing with Mr. Graciano, he's fast asleep in his bed. He clearly did not consent to anything. Let's continue.
Sit back. Cheers, bud. Blue. Wake up, man. Sheriff's Department. Wake up, man. Sheriff's Department, man, wake up. Wake up, man. Wake up. Sheriff's Department, wake up. Sheriff's Department, man, wake up. Don't be swinging. I'm gonna put you in handcuffs. You just...
At that very moment, Deputy Carezza's body cam shuts off, or is turned off. Which is it? I don't know. During the jury trial, after all the witnesses had testified and the evidence had been admitted, Deputy Carezza's defense attorney asked the judge to acquit him, to just take it out of the hands of others. The judge issued an order describing the evidence that was admitted against Deputy Carezza. So I will read to you the findings by the federal judge who presided over this criminal trial. Witness testimony has demonstrated Carezza used force on Mr. Graciano after he was restrained in handcuffs. Indeed, the government's evidence has shown within moments of Carezza entering the locked hotel room of the sleeping Mr. Graciano, the force began. Upon Mr. Graciano waking to the pokes and prods of Carezza, Mr. Graciano swats Carezza with an open hand. Carezza's body camera is switched off, and somehow Mr. Graciano is on the floor of the hotel room in a prone position. in the narrow hall between the bathroom and the bed. Viewing the evidence in the light most favorable to the government, video evidence and witness testimony showed knee strikes and pepper spray deployment after officers Mongold, Carezza, and Co. restrained Mr. Graciano in handcuffs. Law enforcement witnesses have testified that when force was being used on Mr. Graciano while he was handcuffed, they did not use force on Mr. Graciano because they did not believe force was needed at that time. There is sufficient evidence to convict Mr. Carezza because a reasonable jury could find that based on the evidence offered in the government's case in chief, a reasonable officer in his position would find the force used was unreasonable. Therefore, the defendant's motion is denied. In other words, the judge found that sufficient evidence had been presented by the federal government for any reasonable jury to conclude that Deputy Carezza was guilty of the crimes charged in the indictment. But in a criminal prosecution, unlike civil lawsuits, where the courts use an objective standard, here it must be proven that not only did the defendant violate civil rights, constitutional rights, but that he did so with willfulness. Now, what does that mean? According to the jury instructions given to this jury by the judge, a person acts willfully if he acts voluntarily and intentionally with the specific intent to do something the law forbids. So if the government can't prove beyond any reasonable doubt that the defendant did these things, violated constitutional rights with this specific criminal intention to break the law, then he must be acquitted. And here, although the feds were prosecuting, the sheriff, the Monongalia County Sheriff, had this deputy's back. The other officers who were involved who were not being prosecuted really muddied the waters about whether or not Carezza was completely ignorant that he was violating the Constitution. And perhaps that's all it took for a jury to conclude, well, the government hasn't proven what his specific intent was, and he didn't testify, as is his right. So if the jury concluded that he was poorly trained or just completely ignorant, they had to acquit him from a criminal federal prosecution. That does not mean that he didn't violate this man's constitutional rights. This federal judge found there was sufficient evidence for the jury to come back guilty had they chosen to do so. So here we go back to Deputy Coe's body cam, which did catch some of what was happening.
Give me your hands! Why, Sergeant? Go ahead. Give me your hands! Give me your hands! Stop! Please There's the solution. You like that solution? I got that problem solver, man. I got that problem solver, huh? That's the problem solver. Right there, that's the problem solver. Nearby toxins. You see that?
When I say the other cops here muddied the waters for the jury, this is the sort of thing I'm talking about. So in the video, the jury hears Carezza talking about the solution and talking about the problem solving. We all know what he's talking about. This is an excerpt of the jury trial transcript. When Deputy Ethan Mongold was asked under oath, well, what was Carezza talking about? Do you know what the solution or the problem solver was? This was his answer. I don't. Question, do you know why you said give him the solution? And remember, Mongold said give him the solution, responding to Carezza. When he was asked, do you know why you said give him the solution? What was his answer? I don't. I have no recollection of saying it. But he did admit that Mr. Graciano, at that point, was handcuffed with his hands behind his back, which is crucial because all of these uses of force that occurred while Mr. Graciano was handcuffed, at that point were all unreasonable. I mean, unless the jury were convinced otherwise.
Get your feet out. Hey, stop moving. That's all right. Give me that. I can move it. You done moving?
Why is he saying it's hot?
Now, could you calm down and fix my password? I look a mess. I'm all disheveled. Somebody lost their name tag, please. My name tag, you, sir. Really? How is anyone going to identify me as a deputy now? Do this all night long. Yeah, we have too many people in this thing. Just get them out.
The internal investigation file did include one more officer's body cam that captured some of the aftermath.
28663-073.
All you guys intoxicated?
Yes. I came back and drugged them, and we were going to go back and leave.
Okay. Here's what I'm saying. You got a license, everybody's got a license. I'll tell you, right now, this is what we're looking at. You guys will be legal. Okay? But if we don't have any probable cause for an arrest, you guys will be packing your stuff. We'll be waiting for you to get us here. We're trying to stop you guys from getting arrested. If we tell you don't go in there, don't go in there. We tell you to be quiet, be quiet. We're trying to figure out a way to get you guys out of here so nobody gets arrested. Okay?
Don't believe him.
Be quiet until we get it figured out.
Yeah.
Come on, Sarge.
Take care of the top. Save the top, please, Sarge.
They got one.
Please, I didn't know. I was waiting. Stop resisting. Stop stepping on. Stop trying to stop my feet. I'm not trying. Please,
Pertaining to after the footage cuts off, Deputy Carezza was also charged with allegedly lying to the FBI and falsifying his report. In regards to that, the federal judge who heard the evidence during the jury trial had this to say in response to the defendant's motion to dismiss. When a reasonable juror compares the video evidence, witness testimony, and Carezza's use of force report, she could find beyond a reasonable doubt that Carezza falsified his report. Carezza's use of force report states he used knee strikes on Mr. Graciano to gain control of his arms before restraining them in handcuffs. By review of video evidence and witness testimony, a reasonable juror could conclude Carezza used knee strikes on Mr. Graciano after he was handcuffed in the doorway of Mr. Graciano's hotel room leading to the hallway. Carezza omitted use of knee strikes in his use of force report. Similarly, video evidence and witness testimony has demonstrated Carezza's use of pepper spray on Mr. Graciano after he was restrained in handcuffs. But Carezza only reported his use of pepper spray on Mr. Graciano before he was in handcuffs. Finally, Carezza marked himself injured on the use of force form, but he never indicated he was. Also, a reasonable juror can review all the documentary, video, and testimonial evidence admitted during the government's case in chief and find that Carezza intended to impede the FBI's investigation by his knowingly false statements.
Oh, come on, man. Face my property. Destroy my name.
shine. Alright, we'll sit on this bench, man. Do not be spitting and shit. You understand me, Winston? Yes, sir. We don't want to go through the whole thing again, do we? Never again, sir. Alright. Now turn around here and sit down, Winston. Sit. Yes, sir. Alright, let's get some pictures of Winston. Yeah. Winston made some poor decisions tonight, didn't we, Winston? I'll never make them again, sir. Yeah. People say that all the time, Winston. You know what they do, though? They make more poor decisions. Yeah, most people don't, Winston. All right, look straight ahead. Look up here, Winston. Look at me, man. Yes, sir. That one eye not open? Yes, sir. How you take pictures of it? This?
Oh my God. His face. What the fuck is wrong with that cop?
Alright, man. Stand up. Yes, sir. Walk over there to the left in that room. Yes, sir. You want someone to take these off, man? I swear, man. Like, believe it or not, this has been me calm, man. Yes, sir. Even when I was hitting you and shit, that was me calm. If you try to fight me in my house, I will absolutely annihilate you, man. Yes, sir. There's not going to be anything left, man.
That should never come out of a cop's mouth.
This is my home. You do not come into my home.
Nope. It's the people's home. The public's home.
Push your hand straight to the back of your head. You understand that, Winston? Yes, sir. Now, wait, do that, man. I'm gonna read something. Yeah, he's gonna have some marks on his torso. I would imagine. You feel like that was the reason for that? Calm down. I don't think that. Explain the situation when you was about. You don't let's take him like that. Fine. You become a huge thing in my house. I go to the surgery. What do I can do to fix it, sir? Now you see something fixable. Want some new food bargain? I'll do it. Yeah. Me and us do this work? I mean, we definitely improve now. What do you think? All right, Quinn, we'll get you out, man. We'll take some more pictures of you. Hey. Go and stand up. All right. Look straight up. All right. Bring your body to the right, man.
Like, the cop knows he's being recorded. Why the fuck is he acting like this? It's insane. You serve the public, idiot. You don't beat the public. Jesus.
You know what, stand up, man. I'm up to your left. I appreciate you wanting to be super compliant. Don't be breathing on me, man. Don't be breathing on me. There you go.
I guess we can see why they didn't want to give me the footage. Outside of like gruesome death situations, this is some of the most disturbing police body cam footage that I have ever seen. This guy appears to be a complete psychopath.
Yeah.
The way he treated this guy, Mr. Graciano, through all this, do you know what happened with the criminal charges afterwards? The prosecutor's office, on their own, unsolicited, boom, dismissed all the charges. Like they didn't want anything to do with it. I wonder why. Nobody would have ever seen this body cam, but for the feds stepping in. There also was a civil lawsuit and it settled for like 175 grand. And at first I was like, I want to see that body cam because that's a lot. But now after watching it, I feel like no wonder the civil rights lawyers didn't want to give me that footage because the footage is terrible. In my opinion, the settlement should have been way more than that. But hey, look at what the jurors in that jurisdiction did. How can you watch that and acquit that police officer? As a trial lawyer, I respect jury verdicts. I also know that juries get it wrong. This is how we can put it is. The whole police officers accountable. When you have this case, then even then, jurors who want to get the rest of the police officers will bend over backwards to let them off the hook. As we know in our criminal justice system, not guilty does not mean innocent. The prosecution has the burden of proof beyond any reasonable doubt. They don't meet that burden, and perhaps they didn't hear it. The jury has to acquit. That does not mean there were no civil rights violations. There were other elements in a criminal case, a higher burden of proof than you have in a civil rights lawsuit. Maybe the worst part here is that I think this police officer, after he was acquitted, this was the real consequence of what the jury did here. Is now back there in Monongalia County, West Virginia, with a badge and a gun. This police officer, who you see through this video, seems to be absolutely a sadistic psychopath. Absolutely one of the most insane videos I have ever covered. As I said in the beginning, you are a juror. Let me know what is your verdict. You can follow along by subscribing here and also at thecivilrightslawyers.com. You can follow me on Twitter at JohnBryantESP. Remember, our rights don't end where your fear begins. Freedom is scary. Deal with it.
They took a still of an image and sent it to one of these AI facial recognition companies, and that company spit out Angela as their result. The AI gave them a name. They looked at her social media account, said that's good enough.
Imagine that there's some crime committed in Fargo, North Dakota. Cops pull a grainy surveillance photo of a suspect off of a surveillance camera. Then they run that grainy surveillance photo through AI facial recognition software, and it matches with a completely innocent grandmother down in Tennessee who has never even been to North Dakota. Imagine they just run with that AI match and they issue an arrest warrant without performing an actual investigation into whether the AI software was correct. Then, that innocent grandmother is arrested in Tennessee, put in jail on a hold to be extradited to North Dakota. She sits there in a jail for months with nobody even bothering to check and see if she is the actual suspect that they are looking for in North Dakota. You don't have to imagine because that happened. And the grandmother's lawyers are here to tell you how bad this really is.
When I met with Angela, she said she'd never been to North Dakota, never talked to the police from North Dakota, never been on an airplane before, barely left, 100-mile radius of Elizabethton. And then I re-emailed them on like the 10th and said, hey, like, I'm just re-upping this. I don't think you guys have the right person. It's a nightmare scenario in the best case world for the Fargo PD.
I mean, if they can basically grab anyone from around the country who fits into a blurry mass of pixels on a surveillance video, no one's safe.
This lady actually spent a substantial amount of time in jail, it sounds like.
Oh, I probably have to unlock it first. Durr.
Approaching 6 months?
It was only 2 weeks ago that I posted that video from Reno where AI basically told cops to arrest this guy in a casino, and they did. Then last week, it must have been hundreds of you who sent me links to yet another AI false arrest case that hit the news, and this one is even worse. Using AI software, cops in Fargo, North Dakota get an alleged match with this grandmother down in Tennessee. Then doing basically no detective work of their own, they just obtain an arrest warrant and they have her arrested and held in jail to be transported from Tennessee to North Dakota. Never mind that this woman has never even been to the state of North Dakota, never even been on an airplane before. If the AI says it's her, it must be her, right? I mean, that saves a lot of detective work. So I jumped right on it. My paralegal helped me track down and get in touch with the lawyers, and I got to interview both the criminal defense lawyer who freed this woman from jail, as well as the civil rights lawyer who is about to file a civil rights lawsuit. As I mentioned, the Reno one was bad, but this one is actually way worse. Instead of just one night or a couple nights in jail, this woman ended up spending almost 6 months in jail. This is Jay Greenwood, a contract public defender in Fargo, North Dakota. He's the one who discovered that the cops had the wrong woman sitting in jail awaiting trial and then did something about it. You're a lawyer in Fargo, North Dakota. How do you first hear the name Angela Lewis?
I do contract public defender work for the city and the counties around here, and I was assigned to her case on Halloween is when she had her initial appearance, and then I met with her maybe a week and a half after that.
Maybe give me the rundown on what happened here.
We're dealing with someone who is using like a military ID or somebody's ID to go in and do bank fraud involving home equity loans, stuff like that. And somebody had gone into a bank and did this, and they had a video camera over the, when you come in the door, and then they had a video camera over the teller desk that she was dealing with. The police department used a still image. They're not great images, they're from overhead, but they took a still of an image and sent it to one of these AI facial recognition companies, and that company spit out Angela as their result. And so the police department in their initial report says that one of their detectives looked at Angela and then went and looked at all of her social media accounts and said, looks like the lady in the video, and the AI is saying this is her, and so she was charged. So in Tennessee, they arrested her pretty violently, guns drawn, all that jazz. She's at in a trailer park in Elizabethton, Tennessee. They arrest her, put her in jail in Tennessee. North Dakota's asking for extradition, so she's held essentially without bond.
Did she have any connection to North Dakota?
None. No. And so she sat there in Tennessee. Her public defender in Tennessee was just in charge of her extradition, and the extradition process is almost impossible to explain to people, but all they want to know is this the person that North Dakota is looking for? You're not able to argue merits or anything like that. It's just, is this the person? She didn't want to agree to just come to North Dakota. She was fighting extradition, so she sat in Tennessee for like 4 months, 5 months almost.
Do you have any idea how they, just using a photo, connected that to this woman in Tennessee out of Fargo, North Dakota?
It's kind of the uproar, in the community. This story's had real big legs, about what happened. But they didn't do any other investigation. They literally used the AI. The AI gave them a name. They looked at her social media account, said that's good enough, filed for her arrest and warrant for her, and for her charges, and just started the process. That was it. When I met with Angela, she said she'd never been to North Dakota, never talked to the police from North Dakota, never been on an airplane before, barely left, 100-mile radius of Elizabethton. So I just asked her family to give me some bank records so I could verify that she'd been purchasing things, around her house. And when they gave me those, I was able to get the prosecutor and the detective into an interview room. They asked her a bunch of questions, and 5 days later, she was released.
Other than just getting the results from this AI database or AI software, did we know whether they performed any other investigations, such as you just did, and talking to family, asking for credit card records, etc.? Did they do anything?
Zero. It was pretty, and that is the main issue that everyone's upset with. That she had, when I met with Angela afterwards, I asked if she had talked to police, because normally, you're a defense attorney, you're like, have you made any statements to them? Have you told them anything? She's like, no one's talked to me. So they didn't do anything. They didn't speak to anyone in her orbit. They didn't talk to her. They didn't, do what I did, which took, a week. They didn't do any of that. They based it solely on what the computer spit out and what they were able to see from her Facebook, Insta, stuff like that.
When you first met with her, what did she say to you? Did you believe her that, I've never been to North Dakota?
I don't know if it's a belief thing, but we all, as defense attorneys, we all work on proof. I have an alibi. I was never in North Dakota, so I did what I normally do in alibi. In North Dakota, you have to give notice of alibi. You have to tell them who your witnesses are that'll present the alibi. And so I said, do you have any? Were you buying things? Because that's usually a pretty good paper trail. She said, yeah, I was in Elizabethton. I said, can I get your bank record? She goes, I'll have my family send them to you. And so her family emailed them to me. It took like a week, maybe 2 weeks. And then I got them to the state's attorney's office right after that.
All right, so you did their job for them, and you provided the prosecutors with proof that they had the wrong person. What did they do with that? Did they act immediately? Did they sit on it?
They sat on it for a little bit, and I don't know why necessarily. I know there was some tumult and turnover in the office at that time. So the guy that charged the case out, I emailed him probably on the 1st of December. It took a week and a half to meet with Angela or so, and then a couple weeks for her family to give me the stuff, and then I read through it, and I forwarded it to the state's attorney's office, essentially saying, I don't think you guys have the right person. Like, she's buying stuff in Tennessee at the time. She's depositing her Social Security checks at the same time. And if you look back on the bank records, they match the same types of purchases and deposits that she was making 2 months prior to that. So
That was my girl.
I don't think you have the right person. Well, I got no response.
Bye-bye.
And then I re-emailed
Hey,
them
sweetie.
and said, hey, I'm just re-upping this. I don't think you guys have the right person. And at that
I love you so much, Nana Peel.
and said, hey, this has been reassigned to a different prosecutor. So I forwarded it again. Look, Jordan, I think this is the wrong person.
My baby girl.
Once he got it, him and I worked
I love you.
to set up an interview.
I love you, sweetie. You want to come up here?
They did an interview at the jail with me, her, and the prosecutor. And
Hey, baby girl.
Preliminary hearing, which is probable
How are you,
hearing,
sweetheart?
Kind of an old vestige thing. We don't really need them anymore, but we still have them. They just didn't even proceed with the hearing. They just said, we're just going to dismiss.
Do 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 do.
Released her onto the street in North Dakota, or did they send her back to help her get there?
Want to play some string? You ready?
My own, assumptions.
So the craziest part of the story these two lawyers will tell you is not just that this AI mistake was made and this woman spent 6 months incarcerated for no good reason, certainly no justifiable reason. The most shocking part about it was they just basically released Angela out onto the streets of Fargo, North Dakota in the middle of the winter. And this woman was from Tennessee. They didn't deliver her back to Tennessee. They didn't make other accommodations for her. They just said, oops, oh well, see you later. So how did she get back to Tennessee? That's another crazy part of this story, and that's actually a good part of the story, because the local defense bar, the criminal defense lawyers, the public defenders, the private lawyers who defend people in criminal cases in the Fargo, North Dakota area, they are the good guys in this story. They got together their own resources, their own money, and they helped this woman.
The Cass County Jail has what's called winter packages for people that are released from jail and are going out into the cold, because it sucks here in winter, especially around December time. So I think they offered her a coat or something like that. Again, she's from Tennessee. She has no family here. She has no money. She has no anything. They didn't even let her bring her false teeth with her when they arrested her. So she's got nothing in North Dakota. The local defense bar, not me, I mean, there's rules against me giving her money and stuff, but the local defense bar got together some money for a hotel and some food, got her over the 2 days, and then there's a guy in our local community named Adam Martin who runs a foundation called F5 that helps people with felony records get housing and treatment, stuff like that.
How's my girl? Oh, I love you, baby girl. I love you so much.
To Tennessee, he did it in his own personal truck.
That is really insane. I mean, without government, who would arrest the wrong person and take you from Tennessee to Fargo, North Dakota, and then set you out on the street in the middle of winter?
You ready?
In Fargo, North Dakota, with no way to get home.
Yeah, it's a little bonkers. Not a lot of people there. The local police chief and not taking any responsibility, that they had what they needed. He's not backtracking at all. I don't think there is one. He keeps making statements about how the case has been dismissed without prejudice, which happens every single time.
Here's another important part of the story. So while the local defense bar, the F5 project, Mr. Greenwood, they are the good guys in this story. The bad guys in the story, the Fargo Police Department, the leadership completely attempted to dodge accountability and gaslight the public. So after the public finds out about this, and there's outrage, the police chief suddenly resigns/retires. And there's this surprise press conference, I think it was March 11th, where they claim this surprise sudden retirement is basically for family reasons.
So Chief suddenly sends me a letter last night and says, well, sounds like a good idea, Tim, I'm going to retire. So put in his letter of resignation last night for retirement.
How are you?
At the end of the month. Any questions?
I love you, Banana.
Chief, this question's for you. Ethan Kramer, Valley News Live. I'm just curious why
So really the execution of it I think this
I love you, baby.
You'd like to take in, not that you don't enjoy vacation, but an enjoyable vacation.
And almost all the reporters there at this press conference ask all of these ridiculous softball questions like, what is your favorite ice cream? Only one of the reporters asks the actual obvious question that should have been asked by all of them there, and that was about the Angela Lips incident. They completely refuse to answer to the public at that time. They just don't answer the question.
A question, why did nobody from FPD ever speak with Angela Lips for the 5 months she was in jail?
Well, thank you, Matt, for that question, but we're not here to talk about that.
Just for the press, that's an ongoing investigation. Matt's been asking about it, but we have to wait till the investigation is over. Any other questions regarding retirement?
But it's not going away. The public is only getting more outraged. There are media pieces running about the Angela Lips story. So then the police chief does a radio interview where he tries to clarify some of the misinformation and provide so-called context.
You mentioned a review is underway.
You've been at this a long time. Just from a 30,000 foot view, do you see mistakes having been made?
No, I don't. There's always room for improvement. And I think, again, to reiterate, this wasn't on anyone's radar until last weekend. I have no knowledge of this whatsoever, that this had occurred. And as soon as we got the first couple of inquiries, we sent it to our investigation division captain to discuss. And as would be our typical response, it's an ongoing investigation, and we can't talk about it, and we can't condemn in any way any potential persons of interest or suspects. So we have to be very careful there so that the state's attorney can actually carry out their mission as well. That investigation is still ongoing, and we hope in the future be able to definitively know one way or the other what her involvement is or is not, but at this juncture we don't know.
Then apparently that pisses off people on the city council there in Fargo. They have some sort of meeting after that occurs. One of the city commissioners gives a radio interview like the same day or the next day, just tearing the police chief and the mayor apart.
Sir, what happened yesterday, we had an executive session, and in that, basically, everyone tried to deny responsibility and blame other people. The other thing is, this is a huge liability for the taxpayers of Fargo. More than likely, we're going to get sued.
Did anybody answer why somebody was incarcerated for 5 months and nobody went down to see her?
And that's why we have to have a review, because yesterday the police chief and the mayor were totally denying any responsibility or even knowledge. And so we have to find out what exactly went on. And then for the police chief to resign immediately, obviously, there's a lot of very bad things going on. And so we need to have somebody, because yesterday nobody was telling the truth. To me, I'm not surprised at all. That's the first thing you do is evade responsibility and try to blame someone else.
So now, just yesterday, they had another press conference. Did they accept responsibility? Let's continue the conversation, and then we'll get to that.
Imagine the best case scenario for Fargo PD is that Angela was the one that did this, and they somehow come up with a bunch of evidence that, she's this criminal mastermind. And again, I don't think that's true. I think they just have the wrong person. But let's say they find out that she was the one doing this. Their best case scenario was they flew a person here, paid for it, paid for her incarceration in Tennessee. The feds paid for the arrest. We paid for her flight. We paid for her incarceration here. And then they dismissed the case because they didn't have enough evidence to begin with. And they have to start the process all over again and bring her back here? You got to be kidding me. That's a nightmare scenario in a best case world for the Fargo PD.
Anything you can tell me about Angela Lips?
Oh, she's actually incredibly kind, really nice. For someone that had gone through the process she had gone through and was in North Dakota now, having never been here before, she's gone through it, man. She, in addition to the stuff she dealt with here in Tennessee and Fargo, she, I think the local news did a story on her and said that she may have lost her housing, and when you're in jail, sometimes your Social Security disability gets suspended, so she was missing out on some of that stuff. I think she might have lost a pet. So she went through hell.
Because Jay Greenwood was the court-appointed public defender who represented Angela and got her freed from jail. That's basically where his representation ended. Fortunately, Angela was able to hire civil rights lawyers to then begin investigating what happened to her for a potential civil rights lawsuit to be filed. So I also got in touch with the civil rights lawyers who now are representing Angela. They're still investigating, still collecting evidence, but hopefully they are going to be filing this civil lawsuit. This is my conversation with Eric Rice out of Minneapolis, Minnesota, who is one of the two civil rights lawyers now representing Angela. How did this happen? Who screwed up?
And that's what we're currently investigating, so we haven't filed anything yet. We're trying to do our diligence and finding out exactly what occurred. And you do this work, so I think you know that sometimes it's hard to find exactly where the issue occurred, even if the overall issue is pretty apparent. And so that's something we're currently looking into. It does appear that AI was used as an investigative tool by law enforcement. I will say I've seen some police reports in this matter. I'm not sure if they're all of them. What I've seen is that an officer came to Angela because of an AI lead, looked at her social media and says this person could be the one on these blurry surveillance videos, and then that caused an arrest warrant to issue and Angela be extradited and detained and charged. I haven't seen anything in the file that an officer found some sort of geographical connection to North Dakota or some connection to the bank or evidence of Angela improperly gaining or using funds or being connected to the other suspects that they apparently have in custody. So even if you take AI out of the equation, I mean, if an officer sees someone on social media that lives halfway across the country that looks, like somebody could possibly be on a blurry surveillance video, you wouldn't accept that as a sufficient investigation to bring charges and do all of this. And just because AI, initially provided potentially a lead for Angela, I mean, doesn't close that gap.
The more they did, in fact, research her social media, if they did, then the more exculpatory evidence they would have found.
Well, and that's something that initially came to my mind, and we're currently investigating. Like you said, if an officer sees even a face that could potentially, fit within this blur on the surveillance video, if that person has no local connection, the first thing you'd expect an officer to do is say, well, is Angela in the area? Has she been in the area? Does she have any ties? If you can't put her even in the state or in that portion of the country where the crime allegedly occurred, then maybe you should do some more investigation before issuing an arrest warrant.
Government employees will make mistakes, of course, but it's what they do after they realize the mistake is made that is most egregious to me. Here, they could have done the right thing, or they could have helped make it right. Instead, they sort of just turn around on the street in North Dakota in the wintertime, and from what Jay told me, never apologized, and sort of took the position that they didn't do anything wrong.
Yeah, I mean, that's the reporting I've seen. I know the chief has issued some statements, and I think other officials from the city. The tenor of the statements I've seen is essentially, while the officer reported it and a prosecutor signed off and a judge signed off, so obviously it must have been fine, or else, that wouldn't have happened. And essentially, they've also made a fact that Angela was had her case dismissed without prejudice. So, I mean, they kind of left the door open. Well, she could still be a suspect, and we're still investigating. We might come back for her. I haven't seen anything in the file that suggests that Angela is a credible suspect in this matter. And if they didn't have the evidence when they issued the warrant and charged her and tried to bring criminal proceedings against her, I mean, what do they have now? I would say that if they don't have new evidence now that ties Angela to North Dakota or the crime or something better than they had before, they should really clear that air of suspicion for Angela, because she's still dealing with the effects afterward.
And you would think, all right, if they're using this AI software, and I think they're using the flock stuff as well, Jay told me, of course they're using it everywhere, like, why aren't they putting their two little, like, magic tools that they like to rely on together? Like, all right, if this woman who lives in Tennessee somehow committed this crime in Fargo, North Dakota, and you know when this crime was committed, you have a surveillance photo that was taken on a particular day at a particular time. Like, how easy would that be to check and see what her license plate number is, what is her vehicle registration? Did those show up on any of your, like, 1,000 flock cameras between Fargo, North Dakota, and wherever she lives in Tennessee?
And that's what I say. I can't say whether they did or not, because I don't have the full file and all the answers. But I mean, that's, again, not something unexpected or something unusual. That would be a basic investigative tool, is to say, if you have this possible face match in Tennessee, you got to find something that would put her in North Dakota or allows her to get to North Dakota or puts her somewhere in the vicinity. And if you don't have that, then maybe don't claim PC and don't issue an arrest warrant and don't extradite her and make her stand charges, because I mean, that's a basic element you'd expect a prosecutor to have to prove, is that Angela was in that part of the country around the time that these crimes occurred. And if you don't have that piece of evidence, then maybe continue your investigation.
How is Angela doing now?
The department, as you mentioned, hasn't apologized, hasn't taken full responsibility that they messed up or that she couldn't have been suspected. And if anything, they noted her case was dismissed without prejudice. So Angela's having to answer questions about if she's still under suspicion and can she further prove her innocence. And that's what I would say. This case really highlights the dangers of officers relying on AI in this manner. As AI becomes more prevalent and cheaper, you're probably going to see more and more of this, where officers are using it as a shortcut instead of a proper law enforcement investigation. it basically means that anyone can potentially be named as a suspect in these types of cases. Depending on what you have on social media, depending on how clear the surveillance video is, depending on what database or library law enforcement is pulling from. I mean, if they can basically grab anyone from around the country who fits into a blurry mass of pixels on a surveillance video, no one's safe. And that's why it's important that the line be established with Angela's case and with cases like these now, that we expect and demand more from law enforcement to use AI as a tool, but not as a basis itself to charge and extradite a person across the country.
So after I talked to Jay and Aaron, in fact, this was just yesterday, the city of Fargo holds a press conference, another one. And remember, at their earlier press conference, they refused to answer any questions about the Angela Lips incident.
Why did nobody from FPD ever speak with Angela Lips for the 5 months she was in jail?
Well, thank you, Matt, for that question, but we're not here to talk about that.
And in his radio interview, the chief of police claimed they did nothing wrong.
You meant this a long time. Just from a 30,000-foot view, do you see mistakes having been made?
No, I don't, although there's always room for improvement.
But now that more of the public knows that's not true, that was a lie, that was gaslighting, they once again come out publicly and have a press conference about the Angela Lips incident.
We understand that this situation has caused a lot of concern, frustration in our community, and we completely understand that. We've been working diligently to look into this matter in greater detail, and I'll have some reporting out on that, identifying areas where we could have done something better.
They basically try to do some damage control. They say, well, we did not use AI software. It wasn't us. It was our colleagues over at the West Fargo Police Department. It was them. They did it, and they sent us the AI match. We didn't even know about it.
Just in terms of facial recognition technology, facial recognition is a form of artificial intelligence. We don't have any equipment that does facial recognition, artificial intelligence at the Fargo Police Department. At some point, our partner agency over at West Fargo purchased their own AI facial recognition system that we were not aware of at the executive level anyway, and we would not have allowed that to be used, and it has since been prohibited, and I'll talk about that in coming up here. We have always gone through ND Slick, and some of the information that came from the West Fargo AI system is part of the issue. Not necessarily them, but our reliance on that information. Information that we received from West Fargo PD was their submission of the photo from an idea used in one of their fraud cases. They, through their AI system, made that identification of Ms. Lips and forwarded that information, and I would say it's not an identification, it's a potential suspect. But they forwarded that information to our detectives, who then assumed, wrongly, that they had also sent in the surveillance photos with that photo ID. As you can imagine, the photo on the fake ID that I use doesn't necessarily mean that I am the person that's in that fake ID. And so the wrong assumption was that the surveillance photos had been sent. However, the photo did hit on her as a potential person.
If I understand this gaslighting correctly, they're not saying we should not have just relied on AI and we should have performed a more thorough investigation to corroborate some AI match. What they're actually saying is we didn't use AI, we just relied ignorantly on our colleagues' AI over at the West Fargo Police Department that we don't actually usually trust. So we don't have it, and we would not.
How's my girl?
It's
my baby.
Used it, but we didn't know.
I love you so much, baby girl.
We put that into a sworn affidavit presented to a judge that caused this woman to be arrested multiple states away and then jailed for like 6 months. The worst part about this press conference is that when asked by a reporter if they were going to apologize to Angela Lips, He refused to apologize and once again implied or insinuated or even outright alleged that Angela Lips still may be a suspect, despite the fact that he just finished blaming West Fargo Police Department using their unreliable AI.
He apologized for eroding the trust of the community, but a lot of calls have been out there to apologize to Angela Lips. Why not do that?
Sure.
Hi, baby girl.
Valid question, and I think we had a little discussion on that last night as well. So at this juncture, we
You ready?
don't know who's involved and who's not. We're going to have to whittle through all of this kind of vast network of people and who's involved. You could have, this is a large conspiratorial type of operation in which many people are involved. And so kind of just like if you think about a robbery crew. Today we go out, 4 of us, and we do an armed robbery. Today, I got the gun, he takes the money, someone else watches the door. Tomorrow we switch it up. He's got the gun, I watch the door, someone else takes the money. And so there's a lot of people involved in this. So I think that's an appropriate question and response at the right time, but we do not know definitively who's involved and who's not at this juncture.
I mean, what else could they possibly have done? It was AI's fault, and it wasn't our AI, it was their AI. I mean, it's not like we could have done any real investigation work. I mean, we had no way of knowing whether this woman had ever entered the state of North Dakota. We don't have flock cameras everywhere. We don't have the ability to subpoena bank records or credit card records. We don't have the right to call people on the phone and ask them questions. We don't have the ability to walk up to their front door and do a knock and talk. And we definitely don't have any sort of nationwide databases that we can access to find out information about people and, investigate them. There's basically nothing we could do. As Eric explained, there definitely were not only things that they could do, but that constitutionally they are required to do in order to arrest somebody because probable cause is required. Hopefully others will see this and say, you know what, we need to have an AI policy in our policies. Even if there's an AI match, you still need to do police work.
Yeah, and that's a lesson that needs to be driven home. And I think there's 2 aims here that I hope people take away from Angela's case. And one is that this AI face recognition is not reliable and is not meant to be used as a substitute for conventional police investigation. And 2, I hope officers take a moment just to consider the consequences of their actions on the people who are targeted. There are some very basic questions that should have been answered. Was Angela in the area? Could she have been in the area? What do her bank records show? Does she have any tie? Go to the teller, have her identify, and see if she names Angela as the person. And it appears that a lot of that wasn't done. And I think going forward, if officers take to heart that these tools are not an effective substitute for investigation, and that they could cause extreme harm to members of their community that most officers want to help protect, that they'll pause and take a moment to make sure that their efforts are proper.
AI is a powerful tool, but that's what it is. It's a tool. When it comes to having people arrested, you cannot just rely on AI. As lawyers, we use AI all the time. It allows us to do our jobs better. It's a tool. Just like lawyers cannot rely on AI to write their briefs for them. Cops and prosecutors cannot rely on AI to find their suspects for them. But the difference is, when lawyers do that, they get in trouble. It's been all over the news. But on the other hand, when cops do it, when the government does it, they do not hold themselves accountable. What went wrong is very simple. They relied on AI and did absolutely nothing else. Angela Lips paid the price, incarcerated for multiple months. There is a GoFundMe page for Angela Lips, which I will link in the description below. It's currently at $57,802 raised. It was actually very simple, very basic detective work that ironically they could have used AI to do if they really wanted to use AI. I'm sure this won't be the last AI case I do a video on, but I'll continue to follow this one, and if I hear anything else, I'll do an update video. And you can follow along by subscribing both here and at the blog, thecivilrightslawyer.com. You can follow me on X at JohnBryanESQ. Remember, our rights don't end where your fear begins. Freedom is scary. Deal with it.
So basically, I'm wearing this for my protection because when I go out in public, there's people always trying to with me, especially here in East Stewart. Okay. So what am I doing now?
This guy got arrested at a Christmas parade in Florida for wearing a body armor vest concealed under his shirt. The problem is that was not illegal. I saw this in the news with the cops taking a victory lap and Karens rejoicing about it.
I'm still horrified about what happened.
Sounds like he was up to no good.
Why you need that type of protection and why you didn't come out if you were that afraid.
So I put in a request for the footage and I just got it. And it's even worse than I thought it would be. When I say freedom is scary, lawful conduct does not become illegal just because police officers or Karens are afraid of something. My rights don't end where your fear of some perfectly legal object begins. Did you see the video I just did with the Iowa hackers who broke into the courthouse? They revealed just how easy it is to access your private data, not just on the internet, but through courthouses just leaving their front doors unlocked. This can happen to you, and you're at even more risk when you have your exposed personal information on the internet. And this is why I recommend setting up an account with the sponsor of this video, Incogni. Incogni tracks down and removes your personal data from multiple sites, including online directories, people search sites, and even commercial databases. The process is fully automated, so it will continuously remove your data from these places. As of today, Incogni has removed my personal information in 966 different places online. But I also use the custom removal feature available in the Unlimited plan and the Family Unlimited plan to take down almost everything that's exposed about you online. So check out Incogni using the link below or go to incogni.com/civil to get an exclusive 60% off. That's incogni.com/civil and use code CIVIL or click the link below to take your personal data off the market. Now let's get back to the video. Do you remember back around Christmas, it briefly made national news? This guy had been arrested at a Christmas parade in Martin County, Florida.
A scary situation in Stewart after an armed man wearing a bulletproof vest was detained during the city's Christmas parade Friday evening.
It's a treasured Martin County tradition, the 64th annual Stewart Christmas Parade taking place Friday night, but quickly taking a turn when a man showed up in a bulletproof vest with a dagger and a handgun.
Disaster was just narrowly averted, according to the sheriff there. And the public was extremely grateful for the sheriff who had basically saved their lives from this crazy person.
I'm still horrified about what happened, and it should not have happened.
Sounds like he was up to no good and planning for something bad.
Why you need that type of protection and why you didn't come out if you were that afraid is beyond us. I don't know. We don't know what was going to happen. It's hard for us to speculate. We just know it was extremely concerning.
Stewart locals agreeing it was extremely concerning.
The fact that a man was walking around wearing a bulletproof vest and had a knife and a gun clearly to me means intent, and he did mean to scare a lot of people.
I don't usually walk out in a bulletproof vest or with a knife or a gun for that matter. So yeah, sounds like he had bad intent.
While the man's intentions may have seemed off, Sheriff Budenseek says there were no legal grounds to arrest him because of Second Amendment rights, and he was released Friday night.
Who was the crazy person? Well, it was just some guy who showed up to a parade, and he apparently was wearing body armor under his clothes, and he had a pistol on him concealed, and he also had a knife. That's pretty scary, right?
Now, Sheriff Budenseek says they have kept the man's weapons and vest and are looking to issue a risk protection order to keep that man away from firearms until further notice. Now, the sheriff's office tells me today that they are not releasing the name of that man because he wasn't arrested.
So thankfully they got that guy, but the only problem is, well, is it legal to wear body armor in the state of Florida? Yeah, apparently it is. Is it legal to have a concealed pistol on you if you're that guy? If you're not a prohibited person in Florida? Yeah, he was allowed to do that. Was it legal to have a knife on him? Yeah, it was legal to do that. So it seemed weird to me where you have Florida being this allegedly pro-Second Amendment state where it's perfectly legal to have a gun, a knife, as well as body armor. Yet how do we reconcile what happened here and what really did happen here? The news on this I mean, dropped away quickly. So I went ahead and sent in a FOIA request to this county because this county, Martin County, Florida, my own father went to Martin County High School and was their star quarterback who went on to play quarterback for the University of Florida. Anyways, I sent in a FOIA request for the police reports for all the video footage of this incident so that I could see for myself what really happened. They sent me a sizable bill, which just intrigued me more, so I paid it, and I just a couple of days ago received it. So let's go through it. This is where the body cam begins.
It's a misunderstanding. You guys just go through my phone and look at who I'm meeting here. My daughter.
Hold on. Can you move them to Alamanda? That is going to be the cut through if fire rescue needs to get to the ER. I'll try.
So one magazine.
Sure it was. So if you can notify fire rescue, we'll try to make it to Alamanda and Scotia.
One in the chamber.
We're going to try and walk to Alamanda. About 14 years old.
What is wrong?
We don't know yet. You have your wallet on you? You have ID? Hey Jake, you got a glove on you?
Let me know. We can start the parade.
Unfortunately, by the time the body cam footage starts, they already have this guy in custody. There are multiple officers surrounding him. He's being detained. He's being disarmed. They're looking at his pistol. They're checking out his body armor, and they're asking him questions. So there's no footage of the initial interaction that led to him being detained. I do have the police report, so I'll go over that shortly, and I'll tell you what the allegations from the officers are. But just going through the rest of the footage, I mean, you tell me, do you see anything unusual about this guy's activities or the way that he's talking or carrying himself? Does he seem to you to be crazy? Does he seem to you to be intoxicated on something?
Spread your feet to the left. Spread your feet.
Yeah, Jake, it's on the hood. We're going to be walking on the sidewalk on the south side with our light on.
No, I got the signal zero. I've got the signal zero. Okay. That round, I just want to collect it. Okay. Did you eject? Yeah.
26.
Yeah, I just want to collect that round. But actually, doesn't matter. Yeah. It's on the truck. What's that?
371087549.
My the cuff is killing my fucking hand, dude. I swear on everything. It's about to rip my hand out.
Problem 1,
My left hand.
Over, thank you. Back on 1.
You just like.
I'm trying to relax it. It's hurting, dude, bad.
Let me see. Because your watch.
Yeah. Something's bad.
Is that better?
Yeah.
I need to report sweep 534 on the call while the field is being removed.
Oh. Yeah, there's. I didn't check the left side of his vest that he's got on.
There's nothing. So basically, I'm wearing this for my protection because when I go out in public, there's people always trying to with me, especially here in East Stewart.
Okay.
So what am I doing wrong? Hello?
Kilo Bravo Hotel 43, Silver Tacoma.
Literally meeting my whole family right in front of stores. They're waiting for me. I was like, no. They own firearms, but I doubt they have them on them. They ran out the house trying to meet my baby mother and her daughter.
Did we ID him yet or no?
I can tell you.
What's your first name, man?
Matthew.
What's your middle initial?
A.
And last name?
Eagle.
Spell it for me. A.
B.
What's your birthday?
1206.
06. What year?
It's 2000.
What's a good address for you?
So this guy's name is Matthew Beagle, and it appears to me that he is being completely cooperative. He is answering all of their questions. He doesn't appear to be acting in any sort of threatening way. He doesn't appear to be acting out at all in any manner. He appears to be 100% polite and cooperative with these officers, and yet they are holding him and they are giving him no information.
We're gonna take our time. We gotta do a little bit of research and stuff like that, so we're just gonna be chilling right here for a minute.
Oh, you're good. I'm sure he wants.
Damn it, what the fuck?
Am I allowed to put my feet together? Still spread.
6:30, name, date of birth.
One of the officers asks basically, how did we get to this point, to Matthew, and Matthew explains from his point of view what had just happened.
How did we get to this point? Because I kind of walked in after.
This guy thought I was following him up the parade, but I was just trying to get to middle school to see my family.
Gotcha.
Standing there at BP.
Do you know the guy?
No idea who the guy is. But I know I'm well known, so.
Why is that?
Just had a long history in this town. Not bad, just I've had a lot of history.
I don't know you.
Are you new?
No. What was your name? I didn't catch it.
Matthew.
Matthew what?
Eagle.
Eagle? Don't know yet.
What's your last name, Matthew?
Eagle. Yeah. Like the dog.
Can you turn towards me?
Hey, Matt. I got it.
Yeah?
Are you like under the influence of anything? Your eyes are like really bloodshot.
I'm tired.
You're tired?
Yeah.
All right.
The deputy asks him why his eyes are bloodshot. Now, this wouldn't be the first time I did a video showing cops lying to people about their eyes being bloodshot. And just like the other video I'm thinking of, if we look at just the body cam footage here,
Are you like under the influence of anything? Your eyes are like really bloodshot.
it really does not appear that his eyes are bloodshot at all. But it's a cop trick where they lie to you, and now they're getting information out of you. They're getting a statement out of you because they've basically accused you of something, and now you're trying to explain why your eyes are bloodshot, even though they're not really bloodshot, which is really pure manipulation designed to get information that is not even necessarily relevant or credible. They're just fishing for information. Remember, cops can and will lie to you, and just because they ask you why your eyes are bloodshot, that does not mean that your eyes are in fact bloodshot. And that doesn't mean that you have to answer them. You have a right to remain silent. This guy is being completely compliant, and that does not necessarily help him.
And I just got out of the shower.
Okay. You understand like community events and stuff where we're on like heightened alert for like active shooters and stuff like that?
I understand why this is happening right now, yes.
Okay.
And you guys are on point. So,
yeah,
it makes me feel glad that you guys are doing your job. But I really am here just doing this as protection, same reason you guys are. I'm just trying to see my daughter. You'll see it all in my hand. Gladly unlock it.
Matthew explains that he was not up to anything nefarious, that he was just at the parade looking for his daughter. His daughter was there watching the parade, and he was supposed to meet up with her. He couldn't find her. He was looking for her. That's why he was walking around. And he also explains that the reason that he was wearing the vest was because there had been some sort of threat on his life or threats on his life. And he even said he had proof of it and was willing to show it to these cops.
And I also had a person show up to my doorstep last night and threatened to do a lot of stuff. I have it on camera. I was gonna make a police report, but I never got the chance. So it's just kind of like a heightened.
That's like not normal for like, like.
They're banging on my door in the middle of the night saying they're gonna kill me.
Yeah, no, well, like why? I don't
I have
understand.
no idea. I don't even know who it is. Some crazy person just came in the middle of the night. I have a video of it. I'm telling you, I got a lot of history.
So you think someone's like following you or something?
Okay, listen.
And then Matthew gives yet another reason that he was wearing the armored vest. He explains that in the past he had actually worked as an informant for that sheriff's department and apparently felt that there was some sort of safety threat that still existed because of that. And that's why portions of this conversation were actually redacted by the county. But what do we know so far? That he is allowed to possess and wear that body armor as well as the gun, actually has reasons that he's willing to prove to the officer why he was wearing the body armor and carrying the gun. Not that he should have to, but they sort of just ignore what he's saying and continue to detain him handcuffed.
Well, obviously, like, research that, but I honestly don't know you, and what's, like, a detective's name? You said you were gonna report it, but you didn't? Any reason you didn't?
Because it was 3 a.m. and I was tired.
Well, you know, like, law enforcement works 24/7.
No, but I wanted to go back to sleep. I have work.
Where you work at?
You don't gotta take. Are you taking me down to the station to ask some questions?
Honestly, I don't know yet. I really kind of just walked up on this, so as soon as they say what we're gonna do, we'll do that. But for now, you're just detained until they figure out what's going on.
Well, I'm not lying to you, so. If I was coming here to do harm, you think I'd have one mag? For protection.
It's just concerning, you know,
It is.
to have.
I run into people that know me that want to kill me, dude. I don't know what to tell you.
How did anyone know that you had this on you at all?
They didn't. I told him when he walked up to me.
Since we don't have this part on video, the initial interaction, I'll read you the police report that I obtained. It says on December 5th, 2025, the Martin County Sheriff's Office participated in the Stewart Christmas Parade. Due to an increase in mass casualty attacks around the country in recent years, to include attacks at community parades, the Martin County Sheriff's Office provides a heavy security element to ensure safety and security. An additional safety concern is attacks against our elected officials. On December 5th, 2025, at approximately 1930 hours, I was walking westbound on Southeast Ocean Boulevard in the Stewart Christmas Parade. Walking with me was the Martin County Sheriff's Office command staff, Congressman Brian Mast, and the Congressman's Chief of Staff, Stephen Layton. During this time, I observed Mr. Layton say something to Detective Chris Baker, then quickly turn around and walk eastbound against the parade route. Detective Chris Baker is a member of the Sheriff's Office SWAT team and was assigned to dignitary protection during the parade. I then approached Detective Baker and asked him if everything was okay. Detective Baker said that Mr. Layton had observed a male following Congressman Mast, and the male was wearing a jacket. I immediately turned around to make contact with Mr. Layton to ascertain more information. I walked eastbound on Southeast Ocean Boulevard towards Southeast Balboa Street when I observed Mr. Layton standing next to a male on the side of the roadway. During my observation of the male, I saw that he was wearing long jeans, a jean jacket, and a baseball-style hat, which was pulled down low on his forehead. I asked Mr. Layton if this was the male that had been following Congressman Mast, and he said yes. I then approached the male to make contact, at which time he turned his body away from me and motioned as if he was going to walk away. I then called out to the male, later identified as Mr. Matthew Beagle, and shined him with my flashlight. I asked Mr. Beagle what he was doing, and he said looking for his daughter, who was at Stewart Middle. While speaking with Mr. Beagle, I noticed his shirt was pushed forward and could see an outline of something large filling out his shirt. I asked Mr. Beagle if he was wearing a vest, a ballistic vest, and he said yes. Mr. Layton then asked him if he was armed, to which he replied yes. Based on the above and following facts and circumstances, I found it necessary to detain Mr. Beagle and investigate his reasoning for being in the area and his intentions. Mr. Beagle was observed paralleling Congressman Brian Mast for several hundred yards. When Mr. Beagle noticed Mr. Layton looking at him, he stopped walking. Mr. Beagle was wearing jean pants and a jean jacket, which are cold weather clothes. It was a warm evening. I was sweating while walking to the parade. Mr. Beagle's ball cap was pulled low over his forehead. When Mr. Beagle observed me wearing Class A Sheriff's Office uniform, he turned away from me and motioned as if he was going to walk away. During my initial contact with Mr. Beagle, I determined that he was wearing ballistic body armor and was armed with a gun. I then grabbed a hold of Mr. Beagle's arms and wrists and escorted him to a Stewart police vehicle. Once at the Stewart police vehicle, Stewart Police Officer Hogan assisted me in placing Mr. Beagle in handcuffs. Officer Hogan began checking Mr. Beagle for weapons and located a small knife tucked into the front of his belt. I then called for assistance via radio. Sergeant Lott responded to my location, at which time he activated his body-worn camera. Once his body cam was activated, Sergeant Lott and backup deputies continued a search of Mr. Beagle's person for weapons to ensure officer safety during the interaction. During the search, Mr. Beagle was found to have a loaded Glock pistol attached to a rifle-rated ballistic vest. So that's the official government narrative there about what happened. And this is Matthew's explanation to the officer with the body cam.
He saw that I was following alongside. Great, but I'm just walking, trying to get to Sister Ministry.
What'd you tell him?
Told him, hey, I have a gun and a vest on me. And he freaked out. He grabbed me.
Okay.
But I was just telling him because he came up to me with the light.
So were you nervous he was going to do something?
No, I just wanted to tell him so he didn't freak out.
And then he freaked out?
Yeah.
That worked out.
Right? I'm very cool with you guys. I've never ever had a problem with anything. That's why I was exclaiming that I have a firearm on me and a vest.
I'm live. So
Oh, you took photo? Okay, there you go. All right, very good. Yep. So we got that. No? One second. Let me get these off.
You have to take everything off.
This is not going to come off. This stuff's on.
Fuck. Hey, turn this way.
Let me see the shoulder.
Oh, yeah.
Yeah, it's got Velcro in there. There you go.
Alright, it's gonna come down.
There's the other. Here.
I've also got the zero, so. You guys have like a paper bag?
Yeah, Joe, are you good with them now? Go to the trunk. Let's go ahead, come in.
It's fine. I just
Nothing else. I'm just making sure, buddy. That's my job.
You're all good.
Then they take him to the police station, still in handcuffs, still in custody. It's been about an hour since they first took him into custody. We saw the footage where he